And mention for listing of a contempt case for orders.
Why?
Lordship, it is ex gratia payment method. Ex gratia matter. Orders. This is pending since last posting 9/2/2020. Any date maybe.
27th.
Mention for listing for withdrawal there. Same.
When tomorrow?
Right. To item number 40, 40. A matter already become in process, madam.
Huh?
Has become in process, madam.
Item number 40, what happened?
Payment already made, madam. Payment already made, madam.
You want to withdraw?
Yes. Of course.
Mr. M. Hussain. M. Hussain,
Yeah.
the learned counsel appearing on behalf of the petitioner submits that as the petitioner have already received the amount, the petitioner would not further like to press the instant writ petition. Accordingly, the instant writ petition stands closed as infructuous. So, interim orders, if any, stands vacant.
Obvious.
May it please your lordship, with regard to my lord, item number 16, my lord.
16.
Yes, my lord, we'd like to withdraw this matter, my lord.
Your name
B. Bora.
is Bibora Kyoto. Huh? Infructuous no submits that the petitioner would not like to press the instant writ petition. Accordingly, the writ petition stands closed on withdrawal.
I'm obliged.
Yeah, please, your lordship. In item 56, we have filed our dusty affidavit on Friday.
Item?
56, 56. Kindly the record be called for lordship. Of my instruction.
May it please your lordship. Lordship, I beg to mention a listing of a writ petition, lordship. Lordship, the matter pertains to a demarcation of a plot of land, lordship. Lordship, all the pleadings are completed, lordship. It may be listed for admission, lordship.
16.
Yes, lordship. Lordship.
In this case, we have to grant permission to withdraw this case with a liberty to file a fresh one.
Why?
My lord, in this case, my lord, there we are partially mistaken on the main subject matter of this case, my lord. Because we are unknown to some facts now. After field verification report, we have got some facts. So and there needs to be correction in the records, my lord. In the right of records, we have to make correction, and then we have to.
The learned counsel appearing on behalf of the petitioner submits that in view of certain that upon making certain verifications, it had come to light that certain additional facts needs to be incorporated. He therefore submits that he may be permitted to withdraw the instant writ petition with the liberty to refile by incorporating the additional facts. Accordingly, the writ petition stands closed on withdrawal. Liberty, however, is given to the petitioner to refile. Interim orders, if any, stands with it.
I'm appearing for a of 4 minutes.
Give your names.
Obliged, madam.
I'm sorry, my lord. In item number 16, my lord, liberty may be granted to us. Item number 16, my lord.
Hey, to Busairako. We'll see when the matter is there. Why liberty?
Lordship, because my lord, we'd like to file a fresh writ petition, my lord,
Why?
incorporating some
Why?
some points, my lord.
What points?
Some points are left out, my lord.
What points are left? You can't ask for liberty like that. We'll take up the matter. We'll take up the matter.
Yes.
Yes, madam.
Just file the affidavit, madam. Compliance order, madam.
Applied.
Yes, madam. As a lordship affidavit we have filed, is it not your lordship? It is in, whether it is on record, I didn't check, madam. Page 20 is the madam compliance order, madam. It's a rename, madam.
This was the simple thing which could have been
Lordship,
done.
uh,
Told you, na?
Fine.
Uh, Heard Ms. S. Sharma, the learned standing counsel of the Guwahati High Court, as well as Ms. U. Das, the learned additional senior government advocate.
Well-
Ms. U. Das submits that an affidavit has been filed by the respondent number 2. In the said affidavit, an order has been passed. An order has been enclosed as Annexure 1. Whereby the name of Tilokgaon Ranchai Dhan Samabhai Samiti bracket TRS bracket close TRSS bracket close Vidyapur have been renamed as Tilokgaon Ranchai Dhan Samabhai Samiti TRSS bracket to the Bongaigaon. Taking into account the above, it is apparent that the order passed by this court dated 22/9/2019 passed in WPC number 1165/2019 have been duly complied with. Accordingly, the instant petition and instant contempt proceeding stands dropped.
comparison.
So the simple thing. Yes, what is this?
In this case, your lordship, on large occasion,
Yes,
Directed-
government,
as Bora and his name also.
who is there
in
for
that
the
process.
government? Hezbollah is not here.
Let me.
Take up after some time, ask her to come.
Now for
Pass over the matter for the time being, lordship.
What?
Pass over the matter for the time being.
Why? No time being business. Why the
That's
JIRA
the-
value to the petitioner and the land compensation should not be given to the petitioner in equal share, mentioning in the month after hearing the bill. What is this type of matters are this? Why are you before this court?
But the file is not with me. I will call my senior.
Who is your senior?
Mr. A. Rashid. Mr. A. Rashid.
Ask him to come.
Yes.
your lordship, matter may be passed over for the time being, my lord.
Why?
My senior is on legs, my lord, Mr. B. Chakrabarti. Mr. B. Chakrabarti is on legs, my lord. Deeply obliged.
This file, for time being, my lord, my senior. Lovely.
Should we kindly pass over the matter for time being, my lord?
It will go on for 17 months. Challenging the notification of 9/2003.
No. This is different. This is a different matter where they are challenging the 56.
56, yes.
They are not challenging, they are challenging 9.
9, yes, my lord.
9 is
Nine
being
of them.
challenged out here. But the question, however, arises in this matter, how do you take care of your situation?
Fine.
To my knowledge, my lord, one has come up, but it has not been gathered notified.
Which one?
My lord, regarding the first extension. It will be, my lord, gathered notified very shortly. The cabinet has passed it, the government has already approved it, now it will be gathered notified. They have, at a one go, they have not, my lord, accepted all the notifications. My lord. They said they will have to issue separate, gathered notifications, accepting all these notification issued by the central government.
Who,
Regarding-
GST Council?
Yes, PSC council.
So they are giving it.
Well, so that part, of course, my lord, again, be a debatable issue, but as of now, my lord, one, my lord, extension it will be there.
One extension has
Yes,
happened.
we are adopting it. Officially, it will be, my lord, 1 or 2 days, it will be gathered notified.
The nine,
Yes. But
nine you are adopting, not the 56.
that again, it will take some time, but they are doing it now.
But if 56 goes, then nine goes.
Again, my lord,
That adoption
lord.
also goes.
my lord.
So we do one thing, we issue notice making it returnable on 17.
Lord,
We'll hear on that aspect, can it be bifurcated? And on the basis of, this is a very important question which will involve here. Why I'm saying is, just for example, you have been given the power to make the assessment on behalf of the central government.
Yes, yes,
Now you have, the central government has the power as per 9. You did not. So if you did not, central government has the power, then can it be said that the entire demand will go? More particularly in a sense that if you read, you may read in this respect, where the central government, CGST, CGST must be here.
yes, yes.
Where is
Respondent-
CGST?
So may kindly pass to the timing.
Respondent number 2, 1 and 2 is.
CGST is not there.
Yes, it is there, 1 and 2.
My goodness. God save the CGST with this type of councils. Now, you see why I'm saying so. You may read section 9(2) of the Central Sales Tax Act 1956.
Okay.
Not this one, Central Sales Tax.
Yes, I need.
Yes.
I get one.
Why, what happened at that point of time, the power has been given to the state government to make the assessment of the GST, of the VAT, including the sales tax,
Okay.
central sales. Tax. Now, there were certain cases, I think, if I'm not wrong, there is one case of Assam carbon or something. Or there is another case where the question arose as to whether there can be imposition of interest in terms with this. So when that question arose, the Supreme Court said that no, you can't. Because the act does not. Although the power has been given, they invoke the power. Under the 9(2), they invoke the power, but they said that you then also you cannot incorporate the interest which is there, not there in the central systems. So you see here there is a delegation of this authority to you. You may not have the power in view of the limitation.
Might.
But they have the power, but as regards the demand insofar as they are concerned, there is already there.
Right.
Yes, madam. Will issue notice making it returnable on 17/9, nothing further.
But only I would like to, I'm ready with the notice, Lordship, but I'm only to point out, Lordship. Lordship, last time asked me to inform that what are the provisions under which both the state as well as center has the power to levy, the state government, state officials have power to levy central GST as well as state GST. Lordship, under.
No. State authorities have been delegated.
Delegated.
So they will be exercising a power which is already given in the CGST. It is a delegation, nothing more than that. So insofar as the CGST element is concerned, that would be okay because of 9. May not be for them. So under such, we'll consider it on 7,
Yes,
9. This will be a separate matter.
Yes, your lordship.
This is 9 being challenged. 9 challenge is not so good because they have the recommendation out there. But only aspect will be for the state aspect. Issue notice making it returnable on 17/9/2024. None appears on behalf of the CGST on call. Mr. B. Gogoi appears on behalf of the respondent number 3 and 4. The petitioner is directed to serve extra copies of the writ petition upon Mr. S.C. Kyle, the standing counsel of the CGST.
BN Gogoi will be there in this case. BN Gogoi.
Where is he? I know only him. I don't consider the other one.
Yes, your lordship.
S.C. Kyle, the learned counsel. Mr. S.C. Kyle. Extra copies of it. Mr. B. Gogoi accepts the extra copies also may be served upon the AI. The petitioner herein have assailed the notification number 9/2023, whereby the Central Board of Indirect Government of India, Ministry of Finance, Central Board of Indirect Taxes and Customs have extended the period for the financial year 2017 and 18 up to 31st of December 2023 in exercise of the powers under Section 168A of the Central GST Act 2017. The case of the petitioner is as regards the challenge to the said notification number 9/2023 is that there is no element of force measure, and as such, the said notification is bad in law. On the other hand, it is the further case of the petitioner that the state respondents, insofar as the taxes under the Assam State GST, Assam GST Act 2017, have not issued any parametrian notifications in exercise of the powers under Section 168A of the AGST Act 2017. And as such, the exercise of the jurisdiction insofar as the state Assam GST and exercise of the jurisdiction insofar as the taxes under the Assam GST Act 2017 is barred by limitation. The list is the above the respondents are given the liberty to file their affidavit in respect to the instant proceed in respect to this and bring on record their stand. List accordingly.
Much obliged.
Mr. S. Borua, where is he? I've seen it somewhere. Yes, what is your case?
When the case is in land, our land has been acquisition by the Northern National High Authority in law. For
Then
so our land, Pata land, acquired. But proper value not given. As reason number one, lot.
what was given?
Proper value not given. Equal value, land is from the our petition number one husband and petition number two, three, they are their father. They have got the medicine, their name. Petition number one, nothing has been given, and two, three, and they have given some value. But petition number one is totally left out.
So,
That is my lord.
so you have seen the provision of section 384 of the National Highways Act? Have you gone through that? Go there. That authority is there, na? Kindly see 384.
Then will it come on Wednesday, I will try.
What?
Wednesday, I will see and.
What is there? This type of matters cannot. What is happening is because of your delay, you will be losing out. You are not going to get a single penny from here or any relief from here. You have to go there. Why you are not going there? Because unnecessary keeping this matter pending out here doesn't make any sense. Here, there is no, some order says that 3,15,822 have not been paid to the petitioner number one
Well,
on account of no NOC given by the daughter-in-law. Then
But-
produce the NOC. Produce the NOC. As regards the petition number 3 has already received 21 lakhs. Petition number 2 has already received 13 lakhs. Then
something. Yes, 13 lakhs, 83,186.
Yes.
Some amount, yes.
you have already received all these amounts. If you are to go
What
and
with the
submit
petitioner?
your NOC.
Petition number one. Then will I submit them.
Mr. A. Rashid, the learned counsel appearing on behalf of the petitioner submits that in view of the instructions placed by the government advocate to that extent that rupees 21 lakhs 7,984 have already been released to the petitioner number 3, semicolon, rupees 13 lakhs 83,186 having been released to the petitioner number 2, and rupees 3 lakhs 15,822 having not been released to the petitioner number 1 on account of non-furnishing of the NOC by the daughter-in-law of
Petition number one.
the petitioner number 1, he would advise his client to approach the competent authority by furnishing the necessary requirements and necessary documents. He therefore submits that he would not like to further press the instant writ petition. The learned counsel further submitted that in the circumstance the petitioner is aggrieved as regards the apportionment of the amount. The petitioner the withdrawal of the instant writ petition should not prejudice the petitioner to avail remedies under section 3H4 of the National Highway Act 1956. Taking into account the above, the instant writ petition stands closed on withdrawal. However, the petitioner would be at liberty to submit the necessary documents before the competent authority. In addition to that, if the petitioner is aggrieved by the apportionment of the amount, the petitioner would be well within her rights. The petitioner number 1 would be well within her rights to approach the district judge. This is before the district judge, na?
Yes, civil judge.
Huh?
Civil judge.
District judge before the court in terms with section 3H4 of the National Highways Act 1956. Petition accordingly stands closed on withdrawal.
First.
Yes, Mr. Esburua, I asked you to get an instruction. Item number 2.
Yes,
Three.
I have sent my communication and they are to send it within the course of the day. Can it be taken up at 2?
Yes, 2 o'clock.
Lordship, we have filed the required affidavit on Saturday. Perhaps that has not come on the record.
What affidavit?
Your Lordship have permitted us to bring it to record the petition deed. Lordship.
Yes. You
That
have
will
the
be
copy
taken
of
up
the,
on Wednesday or Friday, Lordship.
you have
Along
the
with the,
copy of the affidavit? Give it to me.
Lordship, I have the final degree of in the petition suit also, but that is not properly legible. That's why I have not annexed, Lordship.
Where is the partition decree?
Petition deed is the annection 9.
Where?
I don't have an extra. I have given the official office copy.
Huh? This is a partition, it is not a partition decree, this is a partition by the,
Petition deed in pursuance to the degree. The degree I have, Lordship.
where is the decree?
Lordship.
So now this land is outside. Is your absolute right?
Yes, Lordship.
Where?
Each of us occupying our respective share in pursuance to this degree and the petition deed, Lordship.
Why you have not brought in this? We are concerned with which land? Concerned with which land?
Lordship. It will be the
Oh, what is the impugn order? This one,
Lordship, impugn order.
12/2/2024.
Lordship, it pays 52. 12/2/2024.
There is no option for this authority but to cancel the construction permission for all purposes with immediate and accordingly the process stands cancelled. That the version of the complainant can be interfered with during the hearing, the complainant submitted the construction permission of the land to be one. We do one thing, we issue notice,
Lordship.
only notice, nothing more. You don't write it. Issue notice making it returnable on 4th of November 2024. Ms. Embormon appears on behalf of the respondent number 1. Mr. S. Doctor, the learned senior counsel assisted by so-and-so, appears on behalf of the respondent number 2 and 3. Pusto. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 4, the petitioner is directed to take steps by way of registered as well as usual.
Lordship, and that's the, I may be allowed.
In addition to that, the learned counsel submits that the matter requires an urgent disposal and as such, this court grants liberty to the petitioner to effect service upon the respondent number 4 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein have challenged the order dated 12/2/2024 passed by the Silchar Municipal Board, passed by the executive officer of the Silchar Municipal Board, whereby the permission which have been granted in favor of the petitioner have been cancelled. The case of the petitioner is that the land absolutely belongs to the petitioner.
It was an ancestral land in pursuance to the petition.
Absolutely belongs to the petitioner pursuant to the partition. Pursuant to the formal partition which have been decreed by the court. And as such, and these aspects of the matter have not been taken into consideration by the executive officer of the Silchar Municipal Board in passing the impugned order dated 12/2/2023. The respondents shall bring on record their stand by filing their affidavits on or before the next.
Published. Please, Your Lordship. My lord, I want to amend the writ petition, my lord.
Huh?
I want to amend the writ petition.
Why?
Because, my lord, I have got a communication, order dated 19/10/2021, Deputy Commissioner.
What does it say?
My lord, here in the last paragraph, it is said that land taken should be, the compensation should be paid as per this right to fair compensation, transparency, land acquisition, rehabilitation and resettlement Act 2030. That was decided between the parties. My lord. There was a meeting that we will look into. Last but one paragraph.
No, but the question is,
Because, my lord, on the basis of this decision in the meeting, this subsequent compensation has been determined.
so therefore, why are you not going on the basis of this before that to district judge? Why are you not doing there? This is your case. Go there before the district judge. You have a good case. You see, at the end of the day,
But
this court
only
cannot
thing
pass
is-
this order.
That is there, my lord, as per Telegraphic Act, my lord, under section 16.
You take
compensation
this.
should
This
be
is your
paid to us.
best ground.
Appeal to that, but already, my lord, Deputy Commissioner, in pursuance of this decision, compensation has been decided by the Deputy Commissioner. So, my lord, let me place this on record, my lord, and thereafter, if your lordship decided that after going through this also appeal will lie, then I will go, my lord.
Here has the deputy commissioner fixed any amount?
Yes, my lord,
Where?
Deputy Commissioner, already, my lord.
Where?
Yes, my lord, I'm ready. Your lordship will turn to page 25.
In view of
25,
the
my
above
lord,
and
relevant
considering the
portion,
points,
26
calculation
last
of the land
paragraph, my
commissioner for an amount of rupees only has been done as per the 2000, taking into account the highest value of the land per bigha. So it has already been done.
already been done. That is why that is not paid to us, my lord.
How much it is being paid?
My lord, it is paid only 1,50,000 like this.
Where?
That was decided. That is there, my lord. And thereafter, your lordship will turn to page 20B.
Now you are being paying how much?
20B, my lord, at the bottom, my lord, 1,51,000. Actually, my lord, what they have decided,
Yeah.
that is regarding the house, etc., and the trees, etc., but my land compensation is not given. That is why, my lord, we have
Here
not
they have
discussion
given
in
us
the
7
meeting.
lakhs per bigha.
Yes, my lord. And ultimately, my lord, your lordship, on that basis, this decision has been taken by the Deputy Commissioner after inquiry by the circle officer.
Now, who is he to sign? How? This is done under how? Yes, Mr. Das, how are you making this? Who is the person authority to give the payment of compensation?
By the Power Grid Corporation, my lord.
No, you pay the compensation, but who has the authority to assess?
That is the Deputy Commissioner, my lord, the office of the Deputy Commissioner.
So, Deputy Commissioner, where is your assessment?
That is my according to the assessment.
1,51,000.
Yes, sir, my lord, I am drawing your lordship attention to page 8, my lord, of the writ petition, my lord. They have received in total 31,17,857, my lord, that he has admitted, my lord.
$21 lakhs.
31 lakhs, my lord.
21 lakhs.
Oh, sorry, 20 years.
Now, then if that be so, where is the assessment by the deputy commissioner?
Now, what is the power of the deputy commissioner? Once the assessment has already been assessed by the office, my lord, revenue authority. There is a statutory provision, my lord, as per section 16(3), my lord.
When it has been assessed.
My lord. And against the order passed by this Learning Deputy Commissioner, we have also filed an objection, my lord. That objection is till now that has not been disposed of.
Mr. You have filed objection where?
My lord, my junior will produce the my lord, copy of that, my lord.
He has already been provided to the board.
Objection filed where?
Lordship to the deputy commissioner.
Now, when was the amount paid to you?
Well, the date specifically I have not mentioned.
Now, why have you not mentioned all these things? This is very relevant.
But that is relevant, my lord, but after that, my lord, this, I have filed representation on the basis of this.
No, once the deputy commissioner have already paid, he is functions official. He can't write all these things.
My lord,
You may have all
my
these
humble
things.
submission before your lordship, that is not on record that deputy commissioner decided this compensation. Otherwise, my
How did you get that amount?
my lord, they paid this amount. My humble submission before your lordship, that if that.
No, the most pertinent aspect, no,
There is a
Mr.
meeting.
Sheikh, kindly understand, the most pertinent aspect is that the notice you have been paid and you have not mentioned when, which is very relevant. Because this was done, this 1,51,000 which is being mentioned out here is being done when? 16/4/2022. This payment has been forwarded to you on 16/4/2022, Annexure 3. Whereas the deputy commissioner writes on 17/8/2022.
Yes.
What business does he have to write all these things?
In that case, my lord, position will be clarified by the deputy commissioner before your lordship. Deputy commissioner, I have included party. And that picture will be clear. Then your lordship will decide. Let the deputy commissioner come and say.
You know?
And one thing your lordship will consider, once the deputy commissioner decided the compensation, he cannot redecide. Now 44 lakhs. 44 lakhs.
44 lakhs was done on 17/8/2022. You were paid on 16/4/2022. That is the difference. Why were you paid on 16/4/2022 without an assessment? Are you saying that? Without an assessment?
Without any assessment, I do not say, my lord.
Then
Let the deputy.
Can the deputy commissioner
clarify the
again
position.
reopen something?
My humble submission before your lordship, let the deputy commissioner clarify the position. How he decided this 44 lakhs. And if earlier one is decided by him or not. And if that is so, my lord, what is the relevancy of this meeting? Resolution of the meeting. If already compensation has been decided by the deputy commissioner, then there is no need of this meeting, my lord. And he said that there is a hue and cry, proper compensation is not paid. Let the deputy commissioner clarify the position. Entire picture will be clear by the deputy commissioner. Let me place the order of the deputy commissioner on record, my lord.
No. Issue notice making it returnable on 11th of November 2024. Union? None appears on behalf of the Union of India on call. Power? None appears on behalf of the Power Department of the Government of Assam on call. Mr. N.C. Das, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 3 and 4.
3, 4 and 5.
Miss M. Burman appears for the respondent number 6.
Two, I can.
Okay, 2 and 6. It is the 2 to Nidibo. 2 and 6. As the respondent numbers 2 to 6 are duly represented, extra copies of the writ petition are directed to be served upon them during the course of the day. As regards the petitioner number 1, as regards the respondent number 1, the petitioner is directed to serve an extra copy of the writ petition upon the Deputy Solicitor General of India, Mr. R.K. Deep Chaudhary. The case of the petitioners herein is that the respondent authorities the respondent number 3, 4, and 5 have taken the right of way over the land of the petitioner in terms with Section 10 and 16 of the Indian Telegraph Act 1885, read with the Indian Electricity Act 2003 for the proposed 400 kV DC bracket twin Lapwing LAPWING bracket close Lower Subhansuri Vishwanath Saryali transmission line. It is the case of the petitioner that the petitioner have only been paid an amount of rupees 1,02,230 on account of Jirat and rupees 21,95,627 against the value of the house. There is, however, no mention as to when the petitioner had received the said amount. Be that as it may, it is seen that on 16/4/2022, the entitlement of the petitioner have been duly informed to the petitioner by the communication issued by the respondent numbers 3, 4, and 5. The petitioner thereupon, being aggrieved, had submitted some certain representation before the respondent number 6, who, by the communication dated 17/8/2022, informed the respondent number 3, 4, and 5 that the petitioners ought to receive rupees 44,92,800. It is under such circumstances, as the said amount had not been paid, that is the amount of rupees 44,92,800, which have been assessed by the Deputy Commissioner in terms with the enclosure to the communication dated 17/8/2022, the petitioner has approached this court. The respondents are directed to bring on record their stand by filing an affidavit. This court further directs the Deputy Commissioner to file an affidavit. The District Commissioner, Lakhimpur, to file an affidavit stating entirely as to when when his office have already when did he first assess the compensation as a competent authority under the Indian Telegraph Act 18 কিবা আছিল, no?
1885, my lord. 1885.
And was the payment made to the petitioner as stated above on the basis of such assessment? The Deputy Commissioner shall also clarify in his affidavit as to whether the Deputy Commissioner can still retain jurisdiction to make further assessment after making the assessment, after making an initial assessment which have been acted upon.
Obliged, your lordship.
That I would file an amendment petition.
You file, it's a long time.
Obliged, your lordship.
Yes, what it is?
Lord, we have already submitted the amended post title below. There is a mistake in the array of parties. Respondent number 2 is required to be corrected. That has been done, Miller. Lord, there is a provision for arbitration, Miller, under the National Highways Authorities Act, Miller. So we will approach the arbitrator. That line, my lord, can
You are aggrieved by the
agree by the
compensation.
compensation amount.
Mr. A.R. Bhuya, the learned counsel appearing on behalf of the petitioner, submitted that in view of the dispute involved herein pertains to the grievance of the petitioner as regards the inadequacy of the compensation. The petitioner would not like to further press the instant proceedings. Rather, the petitioner would be well advised to approach the competent authority by filing a representation, by filing a statement of claim. And they hear that already it has been done, na? Competent authority has already done it.
My lord, notification has already been.
No, the amount has been already
Already
assessed.
been assessed, my lord.
Yeah. I'm requesting the competent authority to make a reference in terms with section 3G5 of the National Highway Act. Full stop. He therefore submits that the withdrawal of the instant writ petition should also not prejudice the petitioners in availing such remedy. Full stop. Taking into account that the Act of 2000, the National Highways Act 1956 categorically mandates that the compensation, mandates that if a person is aggrieved by the compensation, if any party is aggrieved by the determination of the compensation, the party can very well approach the competent authority for making a reference to the arbitrator. This court is of the opinion that the instant writ petition needs to be, this court accordingly closes the instant writ petition on withdrawal. The petitioner herein would be at liberty to approach the competent authority if the petitioner is aggrieved by the inadequacy of the compensation. And in doing so, and if such approach is being made, the competent authority is directed to make the reference to the arbitrator within 15 days from the date of the said submission, said representation. With the above the instant petitions. Mr. Bhuya, when you give it or ask them, don't make it's in the form of a representation. Make it in the form of a statement of claim.
Statement of claim, fine.
So that would become easier for the arbitrator. And look at this judgment of 2022-15 SCC page 1. Have a look at it. It will be, I think, very helpful for the purpose of getting a better compensation.
My lord, highly obliged. Apply.
Yes, government.
Lordship, can this matter be taken out after some time? Same period, Lordship.
My lord, before going to the merit of the case, my lord, he has filed one additional affidavit. Lordship will peruse that, my lord.
Where? I'm
This
not
is,
got any.
this is my copy, my lord. He is saying something, my lord. It's very serious. The petitioner, my lord, says that they had served copy on us before filing this petition. And Lordship will go through, my lord.
Yes.
Only just intimation,
No,
my
no,
lord.
no. My lord, when we receive copies, my lord, I have a lot of departments. It's not that I check every file and instruct my authorities
No,
to
no,
do
no,
that.
I am
This
just,
is
just
kind of
intimation.
illegal.
Just intimation, my lord. Here, my lord, Patta land, my lord. It was obtained in the year 2009, my lord.
Hmm.
Periodic Patta, my lord. In spite of that, there is a 2 times inquiry also, my lord, by the deputy commissioner saying that it is a Patta land, my lord.
Hmm.
But forest department is not giving us that, my lord. More specifically, it is clear, my lord. Your lordship, may please to see here, my lord. Page 50, my lord. It was last submitted by the additional deputy commissioner, page 50.
What are you challenging?
Yes, my lord, I am challenging, my lord, only the one plot of land, my lord. Measuring, my lord, it is, my lord, 2 bighas. One plot of land measuring 2 bighas, my lord, we took lease. Thereafter got permission, my lord, from the deputy commissioner, circle officer, my lord, submitted report, my lord, that it is a not forest land.
Where is the eviction notice of the which you are
No, no,
challenging?
nothing.
You are challenging some.
Just, my lord, just last letter was issued, my lord. It was 62 page, last page, my lord. They are saying that in spite of that, it is a forest land.
You are hereby informed on visit area, it is found that you are illegally constructed petrol pump at Cooperative, which area is under Sulphur Reserve Forest as per remand. As per the office record, the several times you were asked to stop the construction work, but you have whimsically constructed work in here. You have violated the forest contract, if any permissible understandings. Then
But deputy commissioner, my lord, agriculture officer, my lord, everybody, my lord. Kali perusal, let's say page 49, my lord, annexion 9. And more specifically, page 50.
who writes this?
The additional deputy commissioner submitted report, my lord.
Then
Second time, my lord. Page 50. In relation to the above inquiry, a letter number so and so has been sent to the ranger Rongzuli forest area, Rongzuli, directing him to appear in the office chamber of the undersigned on 24/8/21 at 11 AM, along with all relevant documents, maps, etc., to support his objection enclosed. As directed, Range Forest Officer Rongzuli had apprised the matter by submitting a report by mentioning Salpara as a reserve forest, had letter number so and so, dated 24/8/21, along with forest notification 23/10/59, and the map of the Salpara Reserve Forest area so and so. After field verification and verifying 2 numbers of reports and the existing land records from the circle officer Rongzuli, it is found that the plot of land measuring 5 bigha, bearing Dag number 60, Patta number 67 is a Khiras Miadi Patta land with class Pirongi.
Poringi, Revenues Village, Kotakuti, Part 4, which is under Rongzili Revenue Circle.
Now what has happened?
Thereafter, my lord, we have installed by taking permission, all prior permission within the government side. Thereafter, fire brigade, thereafter electricity, thereafter agriculture officer, or everything we have installed there, but they have evicted.
Evicted.
Evicted, my lord.
You are not challenging the eviction.
Now, lastly, my lord, after filing this case, they have evicted. Just I have apprised you. My submission is that, my lord, at this stage, my lord, your lordship may please to issue notice to the forest officer, because otherwise all other authorities have given us the consent and all papers are here before your lordship. This is a Patta land, my lord. Exonia given India 1989, subsequently India 2009, my lord. That I have also annexed here, my lord. Map is also there. Kindly peruse your lordship. Page 39.
This is the patta.
Yes, my lord. 31 March 2009. Hora 2029. SP also submitted.
Now,
report.
by way of an additional affidavit, what are you trying to say?
Just I have apprised the honorable court that they have started to, they have entered into our land also.
They have evicted you.
Yes, my lord, evicted in the sense, my lord, they have not demolished all everything, my lord, because we have already established our retail. That is also, my lord, given they also the BPL company also, my lord, submitted representation before the deputy commissioner, my lord. They have given us the approval also. I have annexed here.
But why is the owner not before this court?
Oh, yes, my lord. Honor, my lord, yes,
His land.
yes.
He has given you a lease. Why is he not before this?
Then I can impede him, my lord. He is along with.
Unless you don't make him
Yes, my lord, I can impede.
a party in the instant
Yes, yes.
proceedings, how is it
Here,
possible?
let's, it may allow me to impede. Here, I can impede.
Which side he'll join? He'll join his side or his side?
No.
If he impledes also, it is that landowner, my lord, it is his case, my lord. Landowner just does not, he has done nothing wrong. Which side will come?
No, he
He has
also,
to come. Landowner has to come.
2-3 days ago, he has, the petitioner informed me whether he will be, can be able to, he can be implead as a party also here in my case, my lord. I can implead, my lord.
So why don't you withdraw and file? Because here, why I'm saying it is,
Yes, my lord.
I think if you withdraw and file, it will be better.
Yes,
All
sir.
three of you file.
Yes,
it
my lord,
together.
I can.
Because you mean then have to say your case in a different line
Yes. Well,
and bring in these additional things also, which has happened.
with that liberty, your lordship.
Mr. H. Das, the learned counsel appearing on behalf of the petitioner, submits that the petitioner may be permitted to withdraw the instant writ petition in view of certain subsequent developments which have ensued pursuant to the filing of the writ petition. He also submitted that that in the present facts, the owners of the land who are the lessers is also be required to be brought on record. Accordingly, he therefore submits that he may be permitted to withdraw the instant writ petition with liberty to refile. So, taking into account the above, this court closes the instant writ petition on withdrawal. However, liberty is given to the petitioner to refile by bringing on record the addition, the subsequent facts, as well as also by including the as well as and if so advised, the lesser of the petitioner's land be also made the parties.
All right.
Well,
The petitioner number 1, my lord, is having a plot of land, known as 1 kata, some lesser of knowledge. And this land falls in the dag of, my lord, dag number 3, pata number 1, revenue village, Honda FC ground, my lord. Now, in the same dag, my lord, there is 31 bigha, my lord, total land that falls in the same.
when did you submit the application?
My lord, actually in the year 2017.
Now,
Now, my lord, here we have made the representation. Uh, we have made the representation, my lord.
they must have lost it.
No, actually, because the private respondent has given an objection, my lord. Private requires objection. That is why it is not being processed. So we are requesting the authorities that you should proceed with the.
But we are 7 years down the line.
Yes, my lord.
What is the urgency?
New sale permission, my lord, that is, only a representation has been given by the.
No, what is happening? The sale permission, these authorities are taking it like a civil suit. There's a suit also pending.
Suit is pending. We have also annexed the
Who is the plaintiff there?
private respondent number 5.
And has he got an injunction?
Injunction is in respect of that portion of land. In the land in which he has sought the rights in the respect. In respect of the land, although land falls in the same duct, but it is another different plot of land.
So why you are not asking for a clarification out there?
Maybe clarification.
नाही title suit आम्ही येतो जेतो election 8 चा सांगणार. We are not the party there.
Actually, we are not the party there. In the title suit, we are not the party.
Then how is this suit relevant? Where is the order? Let me see what the deputy commissioner has written.
Next, 8, page 40.
Where?
Next, 8, page 40 onwards.
Page
40.
40? 40 is the plain.
Plain, my lord.
I'm not there. Why it has not happened for the last 7 years? They must have issued a communication to you.
No, my lord, because the private respondent has made a written objection before the deputy commissioner. That is why the sale permission has not.
Where is the private objection?
No, we have made a statement.
Statement.
Page number 36, my lord.
How can this go direct? Tell me.
No, my, I only want my lord sale permission in the portion of land in which I am having possession, my lord. He's it is 11.
You want to sell how much land?
1 तथा 2 lesa to the private petition number 2, my lord.
The petition number 2. Okay. There's an agreement made when?
Agreement made 2015, my lord.
2015.
Next step 2, my lord.
2015.
Yes, my lord.
Then what happened? You applied.
Yes, my lord.
Then where's the objection? Why you are not bringing on record the objection? Then how will the court pass? Tell me. Or are you converting this permission court to this court? Tell me.
No, here, my lord, main thing is that, my lord, the land of the petitioner number 1 is totally different land.
Understood. But show me something to the effect that it is different. Why they have? Because once you file an application, they are to dispose it of within 1 month. Isn't it? Otherwise, they have to write to you that this is the reason which we are not doing it. Have they written to you?
No communication was made. No communication was made. Only that they were verbally called, my lord. We have made one statement. My lord,
Because this case is not going to help you out like this. I'll issue notice. Go on. Another 4-5 years. Okay.
Next.
You should have brought on record these. Anyways, we got issue notice, making it returnable on 18th of November 2024. Mr. Embolman appears on behalf of the respondent number 1, 3, 4. Mr. M. Hazarika appears on behalf of the respondent number 2. Full stop. As the respondent numbers 1 to 4 are duly represented, extra copies of the resolution be served upon them during the course of the day. As regards the respondent number 5, the petitioner is directed to effect service by way of registered as well as usual, and steps be taken within 3 days. The case of the petitioner herein is that the petitioner is aggrieved by the inaction on the part of the respondent number 3 in not granting the permission for which is not granting the permission, the necessary NOC, which is required in terms of section 21A of the Registration Act 1908 insofar as the same is applicable to the state of Assam. It is the case of the petitioner that the land of the petitioner is completely different from the land of the private respondent number 5. However, the respondent authorities, more particularly the Deputy Commissioner, Kamrup, have been, Metro have, more particularly the respondent number 3, have been delaying the disposal of the said application in spite of the mandate stipulated in section 21A of the Registration Act 1908 that the same should be done within a period of 30 days. The respondents shall bring on record their stand by filing the affidavit. Yes, what is this?
My lord, the matter pertains to, my lord, SEM oblique election, my lord, wherein we are apprehending, my lord, that we will not be allowed to participate, my lord, because for the year 2022 and 23, we could not held the SEM oblique election, my lord. And by operation of law, my lord, it had been dissolved and one-man committee had already been constituted, my lord. Now, my lord, if we go by the provision of section 41, clause 8, subsection 8, my lord, it has said that the director shall not be eligible for re-election if so specified in the bylaws. But in our bylaws, my lord, especially made, sorry, my lord, especially made for this cooperative society, there is no bar, my lord. So, my lord, by ventilating our all the grievances, we have made a representation before the, my lord, registered cooperative societies. But, my lord,
Election done?
no, my lord, election has not yet been done.
When it is going to happen?
My lord, within 30th of September, they have proposed, my lord, we have.
So your nominations have been cancelled?
No, no, no. The scope of nomination has not yet come because, my lord, notification has not been issued.
You are approaching this court beforehand? Apprehending?
Apprehending, my lord, apprehending.
My
because-
goodness, there is certain.
My lord, because this is the trend in all the cooperative societies, my lord.
Whatever, maybe go file the election petition.
Lord,
If you are your nomination, how can this court exercise 226 tell me in this type of cases?
Lord, the right to participate in the election, my lord, has been provided in the Cooperative Societies Act, my lord.
Apply, file it. If they reject it, go there within 3 days.
Then, my lord, in the mean, my lord, election petition, my lordship knows, my lord. Then
You have to challenge it like that.
my lord. My lord, we only want that our nomination may be accepted because there is no bar in the.
I
my
can
lord.
do one thing. I can issue notice making it returnable in the month of December. That's all. Would that suffice?
Oh, my lord, may I pray the representation which we have made before the Cooperative Society register, that can be taken a call and can be disposed of.
The representation, they will look into it. If they don't do it, you have already submitted. You
Fine.
make out a good case later on to come when it is rejected by the register. You file your election petition is dismissed. Then I am already here. I'm sitting here for this month.
Lord, if my lord allows me, my lord, a similar order, I have annexed, my lord, in this petition also, my lord.
Every day I get clever with Mr.
My lord.
SK Talukdar always. Where? Similar order where? Considering the facts
yes,
and
yes.
submission of the direct order, the
Is that paid?
provisionally
Is that
allowed to
paid?
submit for contesting the election. My goodness, how is it possible? Possible. This should be too far an exercise of jurisdiction. We are waiting here for moving an unlisted also.
My lord,
Next,
can-
we'll see this matter next month.
my lord.
Withdraw now.
My
Next month. Withdraw now.
My lord.
Next month.
Oh, my
Because
lord.
election will be held now. So we'll see it next month in October or November. We'll see this matter again.
Before 30th, my lord, before 30th of September, can we make it?
That
return?
is why next month,
Oh, my lord, maybe please to issue notice, my lord.
no notice business out here. This unnecessarily, if we keep these matters now, and these are clogs, tomorrow it will have a lot. This is under no circumstances you are going to get anything. Election they will notify, then you will participate. You will participate, then your nomination will be cancelled. If your nomination is cancelled, you have a chance to go and file an election petition.
Right.
Now you want to trot everything at this stage?
No, my lord, we are not stalling the election also, my lord. We only,
No, you are not stalling the election.
Fine.
But the thing is, how to this court exercise on a presumption that they would reject your nomination?
because my lord, the.
Then let them reject your nomination. You have avenues for filing election petition. That day a nomination was rejected, what I did, I passed an order to that effect later on. At 9 and 15. That matter, na? Where it was there, 9%. I dismissed Mr. Bonnick's petition.
Yes.
Where what they did, the register came up out that the nomination was wrongly cancelled in terms with section 42.
Fine.
So under such circumstances, the register also held yes, and as such these directed fresh elections. Fresh election. So you will be there, and that was put to challenge. I dismissed the writ petition. But what is happening out here in the cooperative society, although the basis idea is for democratizing the institution, the respondent authority, the register is taking it as if he is the the king.
My lord.
It's a monarchy. For the register of cooperative society, I think all the matters I've seen, he seems to be the most powerful person in respect of anything. There's no means whatever he feels like he keeps on doing.
My lord, though we have filed the representation long back.
I understand your fear.
My lord. No, my
I
lord, it
understand
will-
the fear.
it will be
Because
done.
you still seem that you are living in not in India, somewhere on the extreme right side, extreme east of Asia.
Fine.
I won't name the country. So,
But my lord, it will happen, my lord. The apprehension is a positive apprehension.
but you have avenues there.
Fine. That's that.
Approach there, not now. Dismiss. Mr. Bhuya,
My lord,
dismiss.
my lord, can it be taken up on next Monday, my lord? Just for a minute.
At the request of Mr. A.R. Bhuya, the matter stands adjourned to be listed again on 16th of
Right.
September.
Obliged. Make the lordship.
Lord, I am aggrieved by Lord the illegal construction of a boundary wall. My lord, deviating from the my lord specifications provided under section 41 of the my lord Assam notified urban areas other than Guwahati rules, my lord, by the respondent number 7.
Who is constructing the boundary wall?
Private respondent number 7, my lord.
And you have submitted a representation to the deputy
I-
commissioner?
My lord, I submitted to the circle officer, to the chairman, my lord, Borpeta Road Municipality Board, to the deputy commissioner, my lord.
No, what is the deputy commissioner's role in these type of things?
My lord, the chairman, my lord, Borpeta Road Municipality Board,
He has a power.
my lord.
He may do so.
I
But what
filed
is the business of AR? And these
One-
were filed when?
representation, my lord.
When were these filed?
Representation was filed only in my lord 14/6/2024, my lord.
Oh?
14/6/2024 before the chairman.
16/5.
16/5, my lord, it was my lord prior to construction, my lord. Then subsequently I filed on 14/6/2024, my lord, phase 22, my lord.
This is the wall. Annexure 2,
My lordship,
the 9 feet wall.
my lord.
Why you are challenging?
My lord, it is beyond, my lord, it has been deviated from the, my lord, specifications provided under section 41, my lord, of the rules, my lord.
41 of that act.
My lordship, it is
Regulation.
1.5, my lord, 1.5 meter center line, my lord, from the frontal street. And this, my lord, is, my lord, 2.74 meters, my lord. That is 9 feet wall, my lord. One aspect, my lord, recent development, my lord, after filing of this writ petition, prior to that, I filed an RTI, my lord. And after filing of this writ petition, my lord, a reply has come, my lord, that circle officer has provided me with this RTI reply, my lord, confirming that the wall is 9 feet. The wall is 9 feet high, my lord.
9 feet high from whose place?
From, my lord, the center line of the frontal street, my lord.
Of the frontal?
Street, my lord.
You are the person in the photograph,
My lordship,
Annexure 2.
my lord.
But tomorrow, if you raise your height of your land, then what happens?
But the street,
No,
on
no,
that
I'm
line,
asking you.
my lord.
Tomorrow, if you raise the height of your land,
Correct.
because it seems your land is, you already have a house?
House, my lord, the wall has completely covered the light and, my lord, the air passes, my lord.
This is on the backside?
My lordship.
Backside?
This is side, my lord.
Huh?
Side wall, my lord.
Side wall?
My lord. And the road, my lord, I have given a photograph of the road also. my lord.
Which is your house?
My lord,
Annexure 2?
the one where I am standing, my lord. The one from where I am taking the color photograph.
So you are standing on your land.
My lord. So my
And
case is,
the
my
other
lord,
side is there, but your house, if we see from inside,
that
that is a different land.
my case is with regard to the road, my lord. The calculation from the road, my lord. Not from my side, my lord, whatever may be, my lord.
From the road.
My lord.
Okay, tomorrow if the road is increased, then it becomes different, huh?
My lordship. Then also, my lord,
I have already informed the executive and therefore taking necessary action based on the previous application. Okay. Mister, why don't you bring on record this document?
my lord,
We'll take it up together.
my lordship,
File an additional affidavit. Then with this, I can ask them why they are not taking
my
action.
lord,
It would be better. No?
my lord. That would be-
Mr. So-and-so, Mr. M.K. Das, the learned counsel appearing on behalf of the petitioner, submits that he has recently received the information from the circle officer, Bornogor Revenue Circle, which has a important bearing in respect to the instant adjudication. This court is upon perusal of the said document, this court is of the opinion that the same is be brought on record by filing an additional affidavit. This is the matter on 16-9.
My lord, deeply obliged.
You file this by way of an, because this is very relevant.
My lord, yeah, my lord.
And you take it up with also in the meantime, you take it up with that Borpeta Minister, because there is a written letter also written by the circle officer to the executive officer.
My lord. Deeply,
Incorporate that aspect also in your affidavit.
my lord,
Incorporate that aspect which has been written to the executive officer of the Borpeta Municipal Board by the circle officer in your affidavit.
my lord, my lord. Deeply obliged. Highly obliged.
They issued a notification for acquiring for four lane construction, my lord. They invited objection, we have given submitted objection. It was heard. Thereafter declared that it is commercial land. Subsequently, in order to re-verify it, some false person, somebody has, he has no existence. On the basis of his complaint, they have again reopened the file. Again heard the matter and saying that it is not commercial land. This is the case, fine. The same authority who initially after spot verification method found that it is that now what happened you will kindly see only because my lord page 28 what they say it is commercial land but it is not recorded in the land record, so it was my you will kindly see page 28 last page. On seeing my lord, first paragraph, my lord, of 3-4 lines, page 28. On seeing the certificate copy of the chitta forwarded by so and so, letter dated so and so, it appears that commercial is not recorded in the land records, though it is stated in the mutation certificate, it is recorded as commercial in third draft code. The draft it has come, my lord, in order to be recorded in the land records, but it takes time, my lord. Only because it is not recorded, so my lord, that was turned down. Idea what was he has modified. And idea his own order, my lord, page 26, his own order, page 26. The same authority. Here also some of the land he was found commercial, some found not commercial. So he has given this page 26. At the time of hearing, your worship.
We are challenging this page 28
Page 28.
by the competent
By
authority.
the towns.
So he has made the determination.
By the town.
3D done.
He did this one also he had done, page 26.
Now, Mr. Chaudhary, kindly, as of now, has there been any in principle approval by the Deputy Commissioner?
No, now there will be, some payment has already been made.
No. Has there been an in principle approval by the Deputy Commissioner in terms of section 5(4) of the
That
reclassification?
we don't have any knowledge.
If you don't have, then how can it be?
But so
Did
much.
you
this
ask
is
for
concerned, my lord.
reclassification?
He is the competent authority. Additional deputy is the competent authority.
No. He does not have the power. It is whether your land was earlier agriculture or what.
Other agricultural land.
So
Right.
when did it become commercial?
Right. It has come, madam, because they have subsequently it developed. Subsequently, this land has developed tremendously, but it has developed.
That
Thereafter,
is
my-
immaterial. That is immaterial.
No, madam, at the time of notification, what happened, at the time of notification, they have recorded the agricultural land. And they asked objection. We filed objection. Objection was heard. Thereafter, it was found that it is commercial. Page 26. Then he himself reopened the file. Then he first was saying, my lord, this into the page 28. And what he is saying, my lord, it is found, it appears from the mutation certificate that it is commercial. But since it is not recorded in the land records, so it cannot be accepted. This is
Likely.
how, my lord, sometimes it takes time, my lord. Suppose mutation, it land record RS patta 1959-62, second RS patta, my lord. Now, third RS patta has not yet been done. So it will be only recorded at the time when this recorded will be prepared, my lord.
No, you can very well ask for reclassification in terms with the
So they
people.
asked me, since I have not paid the chalan, my lord, that's a revenue record, I will pay it, my lord.
No, you pay is a different thing, but
But
the
that
question
tell
I-
me that.
But first of all, where is the in principle approval of the Deputy Commissioner?
That might, of course.
If it is not there, he is right, he has rightly passed this order.
No, deputy manager, that we don't have information at this moment, whether.
But another thing, you see, I passed a recent judgment of Mr. Talukdar's matter, it's the petition number 201 of 2024.
201,
201 of 2024.
24.
The judgment is of dated 28/8/2024. See, there I have taken note of a judgment of the Supreme Court in the case of that is reported in 2022 15 SCC page 1, wherein it says that not only there are when you are acquiring under the parameters which are given under section 3G7 may say many things, but then also you have to apply section 26 and 28 of the right to fair compensation. Now, if we apply section 26 there are three bases. The first is on the basis of the land value, market value, on which it can be, you may have agreements, sale deeds, or whatever may be. The second is on the value of the land, revenue value, which is there. And the third is on the basis of certain agreements or consent which is being agreed. Now, the highest of the exemplar is required to be taken note of. Now, if that be so, what stops you from moving an application under section 3G5, bringing on record, asking those aspects of the matter, irrespective of what is the value if they put it? But the fact is, the order otherwise is right because of the fact that there is nothing, because the law categorically mandates that the classification has to be made by way of a reclassification application. And there has to be an in-principle approval by the Deputy Commissioner. A use of the land for the last 10 years as non-agricultural activities. All these things are required, which is not there. If it is not there, the classification has been rightly put it as agriculture. But the question later on would be whether you are entitled to will be based on those three factors. So instead of that, why you are not going under 3C5? Challenging this thing, you can very well challenge it.
That is one of that arbitration question.
That is the only way out.
So come, it is regarding amount.
That is the inadequacy.
So inadequacy, but in my case, but of nature of the land, they have my lord. Or question come, my lord.
First
If
of
it
all,
is-
you show with me, if we are only going to go into the question of nature of the land, show me when your land has been reclassified as not commercial. That's not there. If it is not there, he's right in passing that order.
He himself has visited the place.
Forget about
himself
he
found-
visiting. The question is he cannot do so because of the fact that the classification has to be as per what is there in the revenue records. The revenue records, you have not gone for reclassification. So the only way out is you have to move there and apply that judgment, which I have said.
Right.
Apply that judgment, applying 26 area. Finally see that judgment.
So
Take
one
it
thing,
up.
my lord, let it come next week. my lord,
Next
let us
week,
see.
you
Let us
ask,
see our-
ask your junior to get hold of that judgment,
Right.
wherein the case which was involved therein was different a bit. There was a case where these people applied for reclassification of the land in the late part of December. There was a communication issued by the Deputy General Manager of NHIGCL that look here, all these lands we are going to acquire, and this is an attempt by which they are trying to change the classification to get higher amounts. On the basis of that, the reclassification applications were rejected. Then this reclassification which was rejected was challenged before this. While the challenge was pending, they came up with a 3A and a 3D notification.
Yes.
Now with the 3D being done, the land now vests upon the central government
Once it is.
by
ready.
operation of the subsection 2. So once it vests out there, the question of reclassification does not arise because it cannot be done. What is to be done? Then I say, how the compensation is to be done. Now, on the basis of that judgment of 2022, I've mentioned now that look here, he is not only to look into what is the value. If you have the 2013 Act, if you see it, it says about 26A, B, and C. A, you may very well show that this is the land, what is the value of the land of these are the sale deeds of this present time of so and so, these are being used as commercial. On the basis of that, you have to do it, irrespective of what is the nomenclature of the land. A nomenclature
Present value.
has to do on the basis, and the word used is the highest of the exemplars is to be applied, meaning thereby A may not apply. If A amongst A, B, and C, A is the highest, you will apply A. So this is how you have to prove it.
3G5 will come subsequently, madam.
Huh?
3G5 will come subsequently. If the
No,
determination
no, no.
amount, if it is inadequate, then I may use that exercise power under section 3G5. Arbitration.
No, no, they have already done. Kindly see, read 3G5.
Yes, sir.
3G5 says there are two options.
Yes.
You may,
If the amount
Yes.
determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the.
so under
So-
such circumstances,
Yes.
then you see 3G7.
Yes. Right, madam. 7. 7th of the competent authority on the arbitration or the arbitrator while determining the amount. So and so shall take into consideration of
These.
these things.
Now, the Supreme Court says that not only that, they have also to take into account 26 and 28 of the Right to Fair Compensation Act. So
Yeah,
26 and 28, when they apply, they cannot only be saying about the value of the land on the basis of what is the revenue value. What is otherwise it was also to be taken is that if you can produce a sale deed or a registered or agreement for sale will you also do. So under such circumstances, these are things which can be very well done there, not here. Because this court cannot. Now, can this court will have to hold this to be right. Because they cannot change the classification under that too when you already have an act of 2015. When the land has been already classified as this agricultural land, you cannot make it commercial or anything else.
But what he says, madam, page 28, he says, madam, but the petitioner, they found it commercial idea, but the petitioner failed to produce challan for depositing the premium for converting the land into commercial revenue. Challan in respect of his commercial claim. On seeing the certified copy of the chitta forwarded by ASO by letter number so and so, it appears that commercial is not recorded in the land record, though it is stated in mutual certificate that it is recorded in commercial. So fail to pay by the show the putting the challan. The challan wonder when I can give my when it will be in the record that it is commercial, then notice will come. Certainly, I will pay.
No, Mr. Chaudhary, that is not. You see, Section 5 of the Reclassification Act 5(1) says that you are to file an application along with
For
an affidavit.
that purpose.
Thereupon, the Deputy Commissioner shall ask the report from the Circle Officer, that is 5(2). 5(3), the report will be submitted by the Deputy Commissioner, by the Circle Officer, and an opinion also will be submitted by the District Level Advisory Committee. On the basis of that, 5(4), the District Commissioner will exercise the power as to how it is to be done, whether to grant the approval, in principle approval or not. Once the in principle approval is given under 5(6), then you are to deposit the premium, and thereby as per Section 6, this becomes a commercial. Now, without this being done, he's right. So therefore, the only recourse available to you is there, which I've said.
Yes.
You have a look at the judgment. I think that may help you out.
That's-
Oh, yeah. Kindly this. This is this. Kindly see.
I'll see my lord, the also give some time.
Yes, yes. You take a copy of this judgment.
Yes.
This will help.
Let us put it in this. Okay, 201 WPC.
Now, this is it. Paragraph 27 onwards. Mr. H.R.A. Chaudhary, the learned senior counsel, seeks for an accommodation. List this matter again on when?
When is the next week was
16th?
16. Oh, let's see.
Yes, you want to withdraw with the liberty?
Withdraw, Lordship, but subsequently I filed one additional affidavit since your Lordship didn't allow. Certain points we have not taken, my lord. We filed one additional affidavit today after the mentioning period is over, your
What
Lordship.
you are asking for?
Lordship, my land is sought to be acquired by the respondent authorities, your Lordship. Notice was issued to me, my lord, fixing the solatium at the rate of 7,61,616 at page 28, your Lordship. Annexure B, which I am challenging. Lordship, my name appears as serial number 10, my lord.
Yes.
Lordship, more particularly page 25, my lord. My name appears as serial number 10. And the person whose name appears as serial number 7, Hemanto Chaudhary, who is the occupier of an adjacent plot of land, my lord. The rate, your Lordship, My rate is at page 29. I know. 20, I have typed out the portion, 7,61,616, your lordship. And the rate fixed as regards that Hemonto Chaudhary pays 30, your lordship. 73,50,574, lordship. I preferred an objection before the respondent authorities, your lordship. To lordship, that the amount is not adequate, your lordship, because the neighboring land, adjacent land, the amount has been fixed at a very high rate. And thereafter, I preferred another objection stating that, your lordship, they have not done the assessment because there are concrete structure, there are other valuables, your lordship, because it is also a plot of land, your lordship, wherein I am continuing my profession, my lord, my business, my lord. But as on that, nothing has been done. Lordship, under section 27, before acquisition is made and before compensation is awarded, the respondent authorities are to assess the plot of land, your lordship, under section 26 of the Right to Fair Compensation Act, my
Why
lord.
you are going into the right to fair compensation?
My lord.
Why you are going into the right to fair compensation? This is done under the Assam Requisition and Acquisition Act
Oh, that's true,
1964.
that's true, your lordship.
So under such circumstances, it will be by that.
Referred to the,
Yes, government. Why you are not making a reference? Yes, you. Why you are not making a reference? This should be constituted to a section 12 application. Make a reference to the court. Make a reference and they will decide it.
Yeah.
But the problem is what you have done is here, you are 2 lessers of land you are giving 7,61,000.
73,50,000.
No, that is for the other one.
other
Yes.
one.
Other person, 2.69 lessers, you have given 73 lakhs. I don't understand how. 72 lakhs, 50,000, so and so. I don't understand how it is being given. 2 lessers of land means how much? 2 lessers is 288 square feet.
288 square.
220. This seems to be okay. 7,61,000 would be okay. But the other one, how do you take care of that?
And lordship, the concrete structures over the plot of land.
Huh?
Concrete structures, your lordship.
There was structure. Here
Yes.
there is no structure.
That instruction I do not have.
No, in your case,
My case, there are concrete structures.
there are structures.
Yes, your lordship. In my objection, I have specifically stated, your lordship. Objection dated 10/1/2024. The details of the structures.
So this is given on 10/1/2024. You should have referred it.
They are coming to demolish the portion, my lord. Unless they do the assessment and all, lordship, then demolition would,
Demolition will obviously be done. They have always, because this is acquisition has happened.
my lord. They are to assess, my
Have you
lord.
seen section 6?
Yes, of the acquisition. Yes, ma'am.
What does it say?
Where any land has been requisitioned under section 3, the state government may use or deal with it in such manner as may appear it to be expedient and may acquire such land by publishing in the official gazette a notice to the effect that the state government has decided to acquire such land in pursuance of the section, where a notice as opposed is published in the official gazette, the requisition land and premises shall on and from the beginning of the day on which the notice is so published vest absolutely the state government, free from all encumbrances in the period of requisition of such land shall end.
So now the land vests with the state government by operation of law. So it will be demolished. There is no quarrel. But the question of compensation is there, which you will get it.
Referred.
But
It
this
should-
has to be referred.
Fine.
But the only problem which you are going to happen is, but I dispose of directing this to be referred
My lord.
to the, but I think why are you not filing it properly? These applications should be filed properly. How, this is not a representation you submit.
My lord, I understand, my lord.
Is
Yes.
section 12,
Yeah, yes, section 12.
read it.
Lordship. That plea I have subsequently taken an additional affidavit, my lord.
Okay, section 12. Mr. Chaudhary, in that matter, that what you call that eco-camp matter,
Yes, my lord.
I have, because your junior has stated, I put it as your submission that you are only interested with this 5,000 square feet,
yes.
nothing to do with the area. as regards the allegation
Yes,
of
yes,
I put it in that order.
That also, my lord.
Yes.
Permission was only for 5,000.
No, I've just put it because your
Yes.
junior made the submission, so there I put it.
Yes.
Because otherwise, that was one loophole they were making, so that is being taken.
Yes, yes.
Lordship.
Yeah.
Yes, there's a,
So you should, would you like to submit a fresh one,
yes,
giving the details properly?
My-
And once you submit, they will make a reference immediately within
my lord,
15 days.
lordship.
Because here, interest will accrue, na?
Yes.
We dispose it
Lordship
of.
judgment is there.
No, no,
Yes,
interest
orders
will
will-
accrue. The Heard Miss B. Bhuya, the learned senior counsel, assisted by so and so. And Miss S. Sharma appears on behalf, Miss M. Hazarika appears on behalf of the respondent number 1, and Miss S. Sharma appears on behalf of the respondent number 2 and 3. The petitioner herein has approached this court being aggrieved by the inadequacy of the compensation by the respondent authorities in respect to acquisition of 2 lectures of land of the petitioner covered by DAG number 4354 included in patta number 130 of village Kamaika under Moza Jalukbari within the district of Kamrup Metro, Assam. It is also seen from the records that the petitioner, thereupon, being aggrieved with the compensation, have represented before the Deputy Commissioner, District Commissioner, Kamrup Metro, on 10/1/2024 and 28/8/2024. But as there was no response received from the respondent number 2, the petitioner has therefore approached this court. From the perusal of the writ petition, it appears that the petitioner is aggrieved by the inadequacy of the compensation. If the petitioner is aggrieved, inadequacy of the compensation, the remedy, therefore, lies under Section 12 of the Assam Land Requisition and Acquisition Act 1964. Taking into account that the acquisition in the instant case has been made under the said Act of 1964. It is further seen that by communications dated 10/1/2024 as well as on 28/8/2024, the petitioner had requested the collector to refer it to the court. For enhancement of the have submitted representations complaining as regards the inadequacy of the compensation. Taking into account the mandate of Section 12 of the Act of 1964, it is the opinion of this court that the petitioner would be well advised if the petitioner submits an application specifically under Section 12 of the Act of 1964 before the District Commission, Kamrup Metro. taking a reference to the court. Ms. B. Sharma, B. Bhuya, the learned senior counsel appearing on behalf of the petitioner submits that the petitioner would file such applications within 15 days. Taking into account the above, this court therefore disposes of the instant petition, thereby granting liberty to submit the application before the District Commissioner, Kamrup Metro Land Acquisition Branch, along with a certified copy of the instant order. It is further observed and directed that in the circumstance the petitioner submits the said application, the District Commissioner, Kamrup Metro, the response number 2, is directed to forthwith and not later than 15 days from the date of submission of the said application, refer the matter to the court, that is the court of the District Judge, Kamrup Metro, for an adjudication as regards the inadequacy of the compensation. With the above, the instant petition stands dismissed.
Lordship, can a direction be given to Deputy Commissioner, District Commissioner to issue a notice that the matter has been referred?
I'm asking him to within 15 days. So he would know, you have to inquire. This is how it works.
Lordship. Obliged.
You make it properly in the form of a statement of claim, not like this. Yes, Mr. Tripula Sulaiman, tell me.
My lord, there are 10 petitioners, my lord. For my lord, our nearby land, my lord, Secretary Boland Territorial Council, my lord, granted, my lord.
What are you challenging?
My lord, they have, my lord, the Secretary of Boland Territorial Council, my lord, allotted 10 bighas of government land for, my lord, dumping ground, my lord.
For whom?
To my lord, Disney Municipal Corporation, my lord.
To whom?
To Disney Municipal Corporation.
Then?
Lord, here, my lord, we have complained because if the dumping ground is, my lord, created there, then my lord, our, my lord, this problem, my lord, because it's a residential area, my lord.
Huh?
Residential area, my lord.
Where?
Can you see, my lord? We have made a complaint at page, my lord. Page 13, my lord.
This is being done by BTC.
PTC.
Oh, BTC is very difficult. Where is the BTC? You have not served a copy to the BTC.
Yes, sir, copy.
Where's the BTC? No BTC. Circular officer comes under your BTC.
Lordship, I'm paired with GMC.
GMC, what is the GMC has to do out here?
Lordship, BTC is college.
This is BTC.
My senior is on legs. The matter may be taken up after some time.
Okay. Now we do one thing, we issue notice. You can accept on behalf of BTC. Okay. Issue notice, making it returnable on 30 September, early 30th of September 2024. Miss so appears and accepts notice on behalf of the respondent number 1, 3, and 4. As regards the respondent number 2, Ms. S. Sharma accepts notice. Extra copies of the petition be served upon them during the course of the day. As regards the respondent number 5, the petitioner is directed to serve effect service by way of registered as well as usual within 2 days from today. In addition to that, the petitioner is also directed to take steps by way of dusty upon the respond number 5 routed through the registry of this court and quick file an affidavit of service on or before the next stage. The case of the petitioners in brief. Mr. Nayak, in this case, I'm not issuing any interim order, but you just find out. Because you see, when you have, there is an act, when there is a dumping ground, if you are making, you have to perform these certain requirements are to be looked into.
Lordship will also look into the aspect, what is the actual purpose of filing this?
Therefore, I'm not issuing.
So Lordship at page 20, Lord.
Yes.
This is the representation, Lordship.
Ah.
Lordship, may kindly see the last 3 lines of the second paragraph. আমাৰ গাঁৱৰ সুদীৰ্ঘ দিনৰ পৰা খেতি বাতি কৰি page 22 NXRC.
Okay. Of the second paragraph.
Second paragraph, last 3 line, I'm reading.
আমাৰ গাঁও
আমাৰ গাঁৱৰ সুদীৰ্ঘ দিনৰ পৰা খেতি বাতি কৰি ভোগ দখল কৰি থকা তৌজি বাহাৰা শ্ৰেণী অনুমানিক 10 বিঘা মাটি জোখমাপ কৰি বিজনী পৌৰসভা কৰ্তৃপক্ষক সমজাই দিয়ে. Then Lordship will come to the next page. Last paragraph. প্ৰস্তাৱিত আৱৰ্জনা গ্ৰাহকৰ মাটিখিনি যদিও চৰকাৰী তৌজি বাহিৰা মাটি কেইবাটাও পৰিয়ালে 2টা প্ৰজন্ম ধৰি খেতি বাতি কৰি কোনোমতে পোহপাল দি আছে, পৰিয়াল পোহপাল দি আছে. So some families are residing there and that is the actual purpose. If the government is going to set up a garbage plant there, these persons will get evicted. That is the purpose, Lordship, of filing this petition. Last 3 lines, Lordship, of that paragraph, Lordship. এনে অৱস্থাত উক্ত মাটিখিনিত আৱৰ্জনাগাৰ পাতিব লাগিলে তেওঁলোকে অতদিনে ভোগ দখল কৰি থকা খেতি কৰাৰ পৰা বঞ্চিত হ'ব আৰু সামগ্ৰিকভাৱে ৰাজ্যখনৰ কৃষি উৎপাদনত তাৰ প্ৰভাৱ পৰিব. So this is the residential area, my lord. Open land.
No, anyway, if it is a residential area, I'm not on that. This 10 bighas, I'm not concerned. You may evict for whatever we mean. But if it is a residential area, then can it be a dumping ground? Look into it. Come up on 38.
On record, Lordship, this is a khas land, government khas land.
Understood. But can you make it a dumping ground? There's a difference out there. No? In a residential area, can you make it a dumping ground? You say, you come up with your stand. I'm not staying anything today. I'm only giving you a notice. Just find out that and come up. The case of the petitioners herein is that the petitioners are all residents of village number 1, Soragaon, Pusta. In and around their residence, the respondent authorities, more particularly the respondent number 3 and 4, have more particularly the Boroland Territorial Council have allotted 10 bighas of land to the respondent number 5 to be used as a dumping ground. In that regard, they had submitted a representation on 24th of April 2023. However, the respondent authorities have not taken in considered the same, and it is under such circumstances the instant writ petition has been filed. Mr. P. Nayak, appearing on behalf of the respondent number 1, 3, and 4, submitted 1, 3, and 4. 3 also, 4 also. Circle officer is yours. DC is not here. Only 1 and 3 and submitted that the instant writ petition is not filed bona fide as would appear from the representation itself. He submitted the basic intention behind filing the instant writ petition is to stall, is at the behest of certain persons who are illegally occupying the government land. So he, however, submits that he would bring on record the stand of the state authorities by filing an affidavit. List accordingly. The respondents, more particularly the respondent number 3, 4, and 1, 3, and 4, shall bring on record their stand by way of an affidavit. Bring it on record. The interim orders shall be considered on the next. You have an interim prayer?
My lord, no, my lord, we'll serve extra copy to him, my lord.
Do you have an interim prayer or not? No prayer. We have it later on, after vacation. No interim prayer. It will taste cool. You should notice. 23rd of October. Yes. What is this?
Lordship, this is for 2018-19, Lordship, the same case, Lordship, 56/2023. We're challenging the notification, time barred, Lordship.
Same as item 7 was not 17. Same as item 7.
No,
Seven,
not,
no.
not at
Seven
not
is
at 7,
different.
Lordship.
This is 18-19, na?
Yes, Lordship. Lordship, on Friday has given an order, Lordship, and similar case.
17 was right.
Friday the Lordship.
এইটো একেই order কৰি দিব। খালি impugn order টো কোনটো আছে চাই লওক। Impugn order টো
Lordship, annexure 10. In all the cases, annexure 10.
lecture 10 page
So 88, Lordship.
all these cases are same.
Lordship, item number 18, 21, 22, 21, 22, 23, 24, 25, 26, 27, 28, and 29.
Which one is not same?
Lordship, all are same.
সেইটো একে type চবৰে হ'ব। These are all made returnable on 17/9.
All are annexure 10, Lordship.
Mr. B and Gogo appears.
Much of it. Lordship, in one or two matters, my name does not appear in the causes, but my name is there in the Lordship, case.
My lord, this disqualification application is pending. And Supreme Court
Mr.
has.
Chaudhary,
My lord.
tomorrow I am having that matter tomorrow as to be spoken to. That SC, okay. Why I am having it, I'm just putting it to you. You see, later on while hearing another matter, I was placed on a question of locus standi. So that's the judgment of 2013 4 SSC page 465. Some Abu Karan or something was named. I've told Mr. Ardhor also, as to, you see, the locus standi in respect to these matters would be only on a person who could be affected by the registration, not on the basis of anything else, that their rights in respect to the reservation is being affected.
Another scheduled tribe.
Yes, so that has been mentioned in that judgment. So, because another aspect what it comes out, you have the FIR was lodged on 31/2023 or something, or 22, whatever it may be, or 20. And the addition of that charge under this SC was done on 7/1. This SC certificate is only on
Month
4/8.
later on.
4/8. So under such circumstances, can this aspect of the matter be looked into in respect to a trial, which is there? Then you see, otherwise everybody will come. Then say, yeah, isn't it? Just for example, tomorrow in an election dispute, if somebody has, is he going to go to the caste certificate? No. he has to therefore prove before in the election trial that he does not belong to SC/ST.
That too by defeated candidate or by an elector.
In this criminal case, he has to, the moment that this is being put out there, that I belong to SC, it is for them to prove it. You may have to cross-examine and so that he does not belong. So that is a subject matter of there.
Whether
Because
anybody
as
else-
of now, you have already got your relief. Because your main problem was there is no, the question of getting an anticipatory bail was there. Now that has already been available, but this is a other larger issue involved to that effect. That can you, because the moment we say that, allow your objection out here means it will also imply that SC/ST Act will be only applicable for caste certificate, with a caste certificate, which will have a very far-reaching consequences.
I'll look into it.
You just have a look into it. And more particularly not as a council. But yeah,
That's
so that,
happening.
that is another thing.
If
And
that is a
also,
fact, my lord,
yes,
I'll definitely look.
yes, because that is a very important aspect. Tomorrow, because if I say so, because there is a reference of Justice Shyam's order where he kept it, saying that don't do anything till it is being decided. This was approved by the
protection is
division
there.
bench and said that within 15 days you do it. Now, the question is, those are interim orders which has happened. But can you relate the caste certificate to the SC/ST Act, which will have a faster way? Because, and why a caste certificate is required? A caste certificate would be required for 15(4) and 16(4).
That's it.
But can it be for anything else? On that, please.
Certainly.
Yes. Yes. Tell me.
Lord, here is a case.
Hmm.
The petitioner is seeking Miller as a deputy leader of the Indian National Congress of the Assam Legislative Assembly,
Hmm.
is seeking disqualification of respondent number 4, my lord, on the ground of voluntarily giving up membership. Now, this petition was filed long back, my lord.
Ah.
Till that nothing has happened. On 2/5/2024, this qualification petition was filed before the Honorable Speaker.
Hmm.
Now, in terms of the Supreme Court judgment, my lord, they are to do it within 3 months.
Oh.
The judgment I have annexed, my lord. Your lordship, will kindly come to page 154.
Who is appearing for them?
Today, perhaps notice will go.
All this, Principal Secretary.
No, state respondents they can take.
Who is appearing for them? Yes. Who is appearing? None. None of this. Honorable Speaker.
2, 3 they can take, my lord. One,
No.
of course, my lord, it will go.
Secretary, Assam Legislative Assembly?
Yes, 2,
No.
3, no, perhaps. No, 2, 3 government.
1, 2, and 3.
One, perhaps, my lord, let notice go. They can take also, but I leave it to her, my lord. Because Speaker of Assembly is not government exactly, my lord, is an independent authority.
2 and 3.
Take notice. 2 and 3 they can take. 2 and 3, my lord. And 4, of course, 1 and 4 will take registered state, my lord. And in respect of 1, lordship will permit us dusty in the office of the Honorable Speaker.
4.
4 also, my lord.
Dusty, you take it.
Yes.
Because you see, if it is the mandate is 3 months,
Yes.
then under such circumstances, we have to take it urgently.
Yes, absolutely.
So, yeah. Issue notice making it returnable. We have it before vacation.
Yes, yes.
Issue notice making it returnable on 27th of September 2024. Full stop. Ms. Sharma accepts notice on behalf of respondent number 2 and 3. And as such, extra copies of the writ petition be served upon her during the course of the day. As regards the respondent number 1 and 4, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. In addition to that, the petitioner is also given the liberty, is also directed to take steps upon the respondent numbers 1 and 4 by way of dusty routed through the registry of this court and file an affidavit of service. The dusty service so herein is being directed on the ground that the matter requires an urgent consideration, taking into account the mandate of the judgment of the Supreme Court in the case of Speaker Haryana Vidhan Sabha versus Kuldeep Bishnoi and others.
In fact, my lord,
Dated.
3 month period has been given by this judgment at page 128. my lord.
Taking into account the judgment of the Supreme Court in the case of
Page 128.
in the case of
It is reported in 2021 16 SCC 503.
in the case of Kesham Megha Chandra Singh versus the Honorable Speaker Manipur Legislative Assembly and others, reported in so and so, wherein the Supreme Court had
Para 30,
categorically
my lord.
opined
Page 154.
that
Somewhere just before, just middle, not middle, just little downwards, bottom. A period of 3 months from the date on which petition is filed is the outer limit within which disqualification petition filed before the speaker must be decided if the constitutional objective.
a dusty service is given, he can decide yourself. Yeah. The case of the petitioner herein is that that he had submitted an application seeking disqualification of the respondent number 4 on 29/5/2024. However, the respondent number 1 have not taken any steps as per the mandate of the judgment. I have not taken any steps for disposal of the said disqualification application. Mr. K. Chaudhary, the learned senior counsel, drew the attention of this court to the judgment of the Supreme Court in the case of Kesam Megha Chandra Singh versus the Honorable Speaker Manipur Legislative Assembly and others, reported in so and so, wherein
At 154 million.
the Supreme Court
Line about 8 from bottom, but absent of exceptional circumstances, or if there is a good reason.
wherein the Supreme Court categorically mentioned that a period of 3 months is the time within which an application for disqualification filed before the speaker has to be decided, absent exceptional circumstances. The learned senior counsel therefore submitted that this is a case where the respondent number 1 have not exercised his jurisdiction as per the mandate of law, for which the writ jurisdiction under Article 2 to 6 of the Constitution have been invoked. The respondent shall, taking into account the above prescription, as laid, taking into account the above law laid down in the case of Kesam Megachandra Singh, this court therefore have is of the opinion that an urgent disposal of the instant petition is required. Accordingly, the respondents shall file their affidavit on or before, bring on record their stand by filing an affidavit. It is, however, made clear that the pendency of the instant petition shall not bar the respondent number 1 to consider and decide the application so filed by the petitioner on 29/5/2024.
20. Yeah, please, your lordship.
Hmm.
The petitioner before your lordship is a registered owner of a vehicle, lordship. And that vehicle, lordship, is a maxi tourist cab. On lordship, 3rd of October 2023, the petitioner submitted a petition for conversion of vehicle from commercial purpose to private. That application is there, lordship, at page number 30.
Then
Thereafter, lordship, they have issued a communication, lordship, page number 31, by which certain directions were given to me. I have complied with all those. Page number 31 may be looked into, lordship.
Proceed paragraph 12, the flag model portion.
you want to convert from tourist to private vehicle.
Yes, lordship.
What is this SLD?
Speed limit device, my lord.
Without that, no, speed limit device is required where?
Personal vehicle, my lord.
Is it?
In each and every vehicle after lordship, the kindly have a look the paragraph 12, is written briefly. May I read, my lord?
Ah.
It may be stated that the vehicle number so and so has been inspected, examined by the MVI concerned for this office and reported that the conversion of the vehicle from tourist cab, tourist maxi cab to private vehicle is permissible, subject to fitment of SLD in the vehicle and renewal of fitness validity. It may be stated that Rule 118 of the Central Motor Vehicle Rules 1989 has been substituted as per Rule 2 of the Gazette Notification of Government of India, Mort, New Delhi, by their notification number 15th April 2015 has directed the state government to fit the SLD in respect of the categories of transport vehicles registered prior to 1st October 2015, which are not already fitted with speed governor. Such transport vehicles shall be equipped or fitted by the operation of those vehicles on or before 1st of April 2016. Copy and close.
Understood.
Yes,
He wants the other way.
private vehicle. He wants.
Where is the requirement in private vehicle?
May kindly have a look at notification, mock notification. I have annexed in the
Where?
this instruction letter, proceed the mock notification.
Every transport vehicle. Transport vehicle is what?
Proceed, there are some, proceed may kindly have a look. I can mark 118.
You may say that he has to remove the SLD.
He has to fit the SLD.
He has to remove the SLD.
He
He's
has to fit.
asking the other way around.
No, my lord, may kindly have a look. The
No, you see, from
notification.
registered number AS25CC from tourist cab to private.
Yes, my lord.
So private is not a transport vehicle.
Lordship, his lordship, my lord, may kindly have a look. There are exemption of such type of vehicles, my lord. Lordship, this is 118. This is my lord. 118 speed governor, my lord.
What?
Speed governor, my lord. Every transport vehicle notified by the central government under subsection 4 of the section 41 of the Motor Vehicle Act 1988, service provided herein and manufactured on or after 1st October 2015 shall be equipped or fitted by the vehicle manufacturer either in the manufacturing stage or in the dealership stage with a speed governor, speed limiting device or speed limiting function have maximum per set speed of 80 km/h, conforming to the standard of so and so as amended from time to time, provided further that the transport vehicles that are two-wheelers, three-wheelers, quadricycles, four-wheels and used for carriage of passengers and their luggage with seating capacity not exceeding 8 persons in addition to driver's seat, MI category, not exceeding 3,500 kg gross vehicle weight. Fine tenders, ambulance, police vehicles verified and certified by a testing agency specified in Rule 126 of have maximum rated speed or not more than 80 km/h shall not be required to equip or fitted with such speed limiting device. These are the exceptions. Otherwise, all vehicles will be fitted. This is a more guideline, my lord.
Show me what is the meaning of transport vehicle? Conjunction rules for central motor vehicles, 1980. What is the meaning of transport vehicle?
Lordship may kindly come to section 41 of the Assam of the Motor Vehicle Act 1998. Then Lordship subsection 4. There is a reference that central government may issue notification. That notification is appended here, Lordship, in this new book at page number 232.
Definition of transport.
Page number 232. I'm having a notification.
What does the speed governor do?
He will decrease the speed limit, my lord.
It does not permit you to increase the
Increase
speed.
the speed. Then limit is maximum 80 kilometer, I think, national highway.
So do you mean to say your car
Yes.
has a speed limit?
Yes, my lord.
How much? 80. It can't go beyond 80.
Yes, it's a national highway, lordship. We can't go beyond that limit.
What is it? Never
Yes,
heard of.
notification, yes,
Uh-uh.
lordship, issued by
No,
the
Lordship, this
government,
is
my
the
lord.
notification, Lordship. Notification SO 124E dated 5th of November. Now transport vehicle and then non-transport vehicle.
Because this is for transport vehicle.
Yes, my lord.
This is not a transport vehicle.
Transport vehicle means a public service vehicle.
Yes, public service vehicle. There the question is.
Private service,
Private service vehicle. That is nothing to
47,
do.
47, my lord.
A private vehicle cannot come in.
Yes, private service vehicle is include the private.
Service is
Private
there.
service vehicle and private vehicle is different.
No, that
Yes,
depends.
private service is different.
Yes.
There is a service.
Private, what is the difference, my lord, by private vehicle and private service vehicle? My learned friend will appraise its honorable court.
It's
47
Where?
is very clear. 47.
Transport vehicle. Where is the transport vehicle definition?
47, my lord.
Transport means a public service vehicle, a good carriage, an educational area, or a private service vehicle. Now, what is private vehicle? Private vehicle. Vehicle. Private. Yeah. It is defined. Private service means a motor vehicle constructed or adopted to carry more than 6 passengers, excluding the driver, and ordinarily used by or on behalf of the owner of such vehicle for the purpose of carrying persons for or in connection with his trade, business, otherwise than for higher reward, but does not include a motor used for public purpose.
Yes.
Now, therefore, that is why I put the question to you.
Sure.
Your car cannot have a governor. No cars have. I have-
In my car, my lord.
I have all my cars. There's no governor business. Private vehicles, they no governor. But all other cars, if you have today you buy a Innova out there and go out there and say that I'm buying it for transport purpose, they'll have to put the governor.
But lordship, this is a mode notification. We are following this notification. We have
Understood,
to
but
pay
that is for transport.
More to the party respondent here, my lord.
That is for transport.
Lordship, I need to file affidavit, my lord, but they have to.
But if you have come up with this, how is it possible? This is not transport vehicle. Well, show me your vehicle. How much? Where's your registration?
Initially, it was tourist cab, tourist maxi cab.
Where's your registration?
That registration is at page number 22, Lord. And permit is Lordship at page number 24, Lordship.
Seating capacity is 7, including driver. And what is private?
6. It's 6, I think, my lord.
What vehicle is this? What vehicle is this? Make? Company? Mahindra. Quanto.
Mahindra Quanto.
You can't use it for in your trade purpose.
Oh, Lord, I will use it for my private personal use only, Lordship.
Then
That is why, Lordship, I want cancellation of my permit, Lordship, and Lordship, conversion of my vehicle into a private one, Lordship.
that is why he is.
Initially, my lord, Lordship kindly has a look, page 31 of
Oh.
the petition, my lord. He has made an application before the State Transport Authority, and State Transport Authority has directed the DTO to do the needful if he has fulfilling the following condition.
Up to, with respect to, I have submitted a prayer for permission to convert against the, we have no objection to convert the above vehicle. Thank you. Payment up to date, disposal of all pending as a cancellation of HPA, NOC, surrender down. This is, yes, these are rightly done.
Yes, after that, the DTO has very,
Why is the DTO doing all these problems unnecessarily?
because this more notification we are following. my
No,
lord.
that is for transport vehicle.
Because his present the capacity is more than 6, my lord.
But if he's not using it for trade purpose.
I will not use it, Lord. I will use it for my personal use only. And so far as these directions are concerned, Lordship, I have already complied with all the documents are here, Lordship.
But fitness certificate is not up to date, he will submit up to date fitness certificate, my lord, as per the
Fitness
instruction.
certificate
That
was-
he will give it. Up to the fitness certificate, he will give it.
No, Lordship. Now the problem is that, Lordship, they are not issuing the up-to-date fitness certificate as because, Lordship, I don't have that as speed limit device. They
That
are
I will say not necessary.
Yes,
In the government of Assam also, that I have written in the instruction, point number 16, my lord. 16. Yes.
No fitness certificate shall be issued unless the vehicle is fitted with the iman of the prescribed. But this fitment is, speed governor is only required where it's a transport vehicle. It is not a transport vehicle, matter ends there.
Yes, Lord.
Lordship may kindly take up the matter on Wednesday. I will get specific instruction regarding his type of his vehicle. My lord may dispose of the matter. Wednesday, my lord.
She'll notice, take it back.
Sure.
Yeah, I was therefore surprised because none of my cars have speed vehicles.
The indicator in my car, my lord.
Huh?
2 years back, I bought my car, Creta, the highway. If I increase my,
Then it makes a
Indicator, yes.
beeping sound.
yes,
That's a different from the governor. Governor is a thing by which speed does not go beyond 80.
my
It
lord.
stops.
Lordship, I will get the.
Issue notice making it returnable on 18th of September 2024.
Lordship, may kindly have take up the after 23rd of September.
You said next week.
Then
I never said
Wednesday, my lord. Wednesday.
this Wednesday,
In Wednesday, my lord. I will get the instruction only.
13th. Issue notice making it returnable on 13/8/9/2024. Miss Swans MD Bora appears on behalf of the respondent numbers 1, 2, 3, and 4. As she has duly submitted, extra copies of the petition be served upon her during the course of the day. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in converting the vehicle of the petitioner bearing registration number AS25CC 5504 from tourist cab public tourist maxi cab to private as prayed for by the petitioner by the application dated 3rd of October 2023. The learning council appearing on behalf of the respondent submitted that the petitioner's application have not been considered, taking into account that the petitioner does not have a speed
Limit device.
limit device. And the petitioner has to install a speed limit device and also does not have a fitness certificate. It is also seen that during the course of the hearing that the fitness certificate is only issued if a transport vehicle has the speed limit device. However, the question arose as to whether the petitioner's vehicle can at all be considered to be a speed limit would at all be required for the purpose of required to be fitted with a governor in terms with Rule 118 of the Central Motor Vehicle Rules 1989. More so, taking into account the definition of transport vehicle given in section 247, 2 bracket 47. A rule given in rule or section, section 247 of the Motor Vehicles Act 1988, as well as the definition of private vehicle, private service vehicle mentioned in section 2 bracket 33. 33?
Yes, Lordship.
Yes.
233 of the said Act of 1988. Ms. M.D. Bora, the learned
Yes,
counsel
Lordship,
submits that,
233.
submits that she would take instructions in the matter and place it on the next day.
13th, my lord, Friday. Lordship, obliging.
Highly obliged.
This petition with liberty to file appropriate application and appropriate forum.
Reverted for what?
To approach appropriate forum.
Lordship, may I please your Lordship? If Lordship granted liberty, it will renew his the limitation. Lordship.
Huh?
He tried to cover up his limitation by the liberty of procedural report. Already that he has failed to find the exhibition during the period of limitation. And Lordship is clear in mind in either occasion.
Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions not to press the instant petition, taking into account that this court would not be the proper forum. He, however, submits that he may be permitted to avail other remedies. However, he however submits that the withdrawal of the instant writ petition should not preclude the petitioner to avail other remedies. Mr. P.P. Doctor, the learned counsel appearing on behalf of the respondent, numbers 2 and 3, submitted that the liberty should not be granted in view of the fact that this would again open this would provide a fresh cause of action to the petitioner in respect to a time-barred claim. This court, having heard the learned counsels for the parties, is of the opinion that the petitioner this court closes the instant writ petition on withdrawal. The petitioner, however, would be at the withdrawal of the instant petition shall not, however, preclude the petitioner to avail other remedies, provided the same are permissible under law. I think that will be 62.
To fix, item 65 Act 2, my lord.
Yes, sir, he'll call it. Yes, what is this?
My lord, this was a repetition which we had challenged a notification issued by them appointing an ad hoc chairman to a regulated market committee. And I was holding the position of chairman until then. And they had sought to remove me by saying that my tenure was over. But we have a different interpretation of the provision under which they had sought to appoint an ad hoc chairman. that appointed the chairman under section 48, my lord. And in our submission, they could not have done it because it talks of a delegated power. And section 48 does not extend to appointing an ad hoc chairman for a regulated market committee. Nevertheless, my lord, when the matter was proceeding, the honorable court was more inclined to direct them to give a time frame to hold a fresh election. Because even in the notification appointing the ad hoc chairman, it was stated that appropriate steps are to be taken by the ad hoc chairman, who is also a member of the election committee, that it will have to be expedited and elections have to be followed. And then they have, in both the affidavits that is filed by the Secretary of Agriculture and the District Agriculture Officer, both have submitted on oath that the process of election has been initiated or departmentally. And on the last occasion, my lord, a letter was handed over.
Where is the impugned order?
My impugned order was, my lord, at page number 53 of my petition. My lord, the last line. It says that in appropriate time, necessary steps pertaining to the election process will be taken. Now, it stipulates that there is no regulated time in which it has to be held. However, the rules provide how many days are to be taken for each process. For the electoral rolls preparation, this many days have to be taken for etc. etc. So they have not adhered to this timeline. And on the last occasion, they have submitted an instruction to your lordship saying that because of such and such reasons, it's not possible to hold the elections at all. Now, the implication of that is that while the Act envisages a democratically elected regulated market committee to be functioning at all time, since 2023, there has been no elected committee because I have not been allowed to function. And an ad hoc chairman is taking all the power of that committee. And there is no sight of elections in the near future. So, my lord, that's the grievances of now. And my lord, the letter that was submitted on the last occasion to your lordship is totally contradictory to their stand on the previous affidavits they have filed. Both the district agriculture officer and the secretary of the agriculture department have stated on oath in the affidavits that we are in the process of holding elections. And then the joint secretary comes up and says that no, we cannot hold the elections. They have resigned, my lord, from this stand.
I am for a marketing rule also. As per rule also, we have already constituted the election committee. Now the government will hold the election also. This is the necessary party.
Last occasion I have placed an instruction also. The election to the Gaon Panchayats will be held in December also. So after that, for the marketing committee, there has to be elected members, voters from the Gaon Panchayat. The problem is that the Gaon Panchayat elections not yet held also.
Who are the members of the market committee?
Kindly, Lordship, kindly peruse this.
Page 23 it was an extra seal also. This is the notification issued by the chief executive officer Assam State Agriculture Marketing Board also, wherein the election committee was constituted also. The deputy commissioner Huda is the chairman. The deputy registrar Cooperative Society Nagaon is a member, and the district.
No, I'm not there. Who are members of the market committee?
My lord, kindly pay section 8 of the Act, yes. The composition of the committee is stated.
Page 32 of the Act also.
The Gaon Panchayat has been dissolved on February 2024.
Now you don't have a Gaon Panchayat.
Yes, that is the problem. What should be peruses my
Others are no problem, na?
Lordship. The license is also a problem, Lordship, the trade license.
Gram Panchayat is okay, but how do you take care of 812?
812 Lordship, the trader's license is also renewed, not renewed Lordship. The Assam State Agricultural Marketing Board, while letter dated 12 June 2020 had put restriction on collection of market fee or cess or levy in scheduled farmers producers. Hence, the traders' license are not renewed by the Lanka Regulated Market Committee, and for which 3 traders constituency members cannot be elected.
How do you take care of this?
Forest
This
Lordship
cannot,
we
this
have to
Gram Panchayat election may be held. 7 in agriculture, all these things can happen, but how do you take care of 2?
traders' license.
Because you cannot collect now cess.
Collection of cess, sir. 12/6/2020.
Huh?
12/6/2020, collection of cess is totally stopped.
20. 12/6/20. You have to stop. In view of that judge notification.
And also, my lord order is that the collection of cess is illegal. What was it in WP?
Huh?
What's this order also there also?
That is in Bhatta traders. No, that is another thing, but 12/6/2020, there is nothing. So there cannot be a trader. So how, that means there cannot be a constitution. Then who are you? Defunct? Means how can there be, anybody be a ad hoc chairman? What is this ad hoc chairman? Means that means there cannot be a committee at all. How can there be a ad hoc chairman?
48 Lordship.
48 also okay, but there is no committee.
As on that, there is no comment. Yes, sir.
Then how can there be a ad hoc chairman? And there cannot be a committee at all because they don't have the right.
The government can delegate the power to a chair.
Oh.
Section
But
48.
there can be an ad hoc chairman where? In a committee. But the committee is not there. How can there be an ad hoc chairman? You don't hold the election, it's a different thing. But if the committee is not there, how do you do it? Unlike provisions where Cooperative Society Act or in Municipal Act, there is a provision that what will happen when there is a dissolution. But here, there is no committee. The government may act, but can there be a chairman of a committee which is not in existence? Answer the question.
So department appoint the ad hoc chairman.
Of what?
For functioning the regulated market committee.
That is a different thing. The department may, whoever may do, whatever may do, but he has to be an officer. But where is the power?
Section 48 Lordship, may I read? Lordship?
48 says that they may have a board or whatever may be, they may appoint chairman and all. Very well, they can. But appoint where? There has to be something. Now, you are appointing a chairman or an ad hoc chairman or anything of a committee which is not in existence. How do you take care of that situation?
Perhaps, my lord, in my humble understanding, the answer perhaps lies in clause 2, subsection 2 of section 9. It may like, my lord, we kindly read it. Perhaps the legislature saw this as a possible future and hence they provided for it.
What does it say?
It says that if it is not possible to elect any of the members from any of these representative group of committees, then director is empowered to nominate such members to the board so that the perpetual function of the board continues, irrespective of whether it is elected.
We are reading
Section 8, clause subsection 2, my lord. If I may kindly read.
Okay, notwithstanding
Yes.
anything contained in subsection, on the failure of any organization, person or authority to elect any person under subsection 1 within a period of 3 months from the date of occurrence of the vacancy, the director shall give notice in writing to the organization person to elect the members within 1 month from the date of such notice, and on failure of the organization, person or authority to elect the member within the year, the director shall nominate a member, a person on behalf of such organization in the year. So therefore, these problems is addressed under section 8.2.
Yes, in my humble opinion. Yes.
Director of the board.
Because my lord, this has to be read.
Director of the board.
Who is the director?
Director of the marketing board. Lordship.
Because, my lord, this has to be read in harmony with section 30, which talks about perpetual succession. This has to be read in harmony with section 30, which says that it will be a perpetual body. Unless the legislature so repeals it, it cannot be otherwise.
Where it says for perpetual?
Section 13, my lord.
30.
13. Every market committee shall be a body corporate by such name as the state government may specify by notification in the official gazette. It shall have perpetual succession and a common seat, may sue or be sued in its corporate name, and shall be competent to acquire and hold lease, so and so. So this board is never envisaged to have been diluted by any other factor, except by way of repeal by the legislature. So it is in this context that section 8, subsection 2 has to be appreciated, my lord, in my humble understanding.
No, or in other words, these justifications which are given are contrary to section 8.
Yes, of course. That's my submission.
Therefore, if the market committee has perpetual succession, there can be a chairman.
Yes.
What will happen to the other members?
That's why the subsection 2 is.
Now, is he functioning without members?
No, then the director will have to nominate. Yes.
As of now, whether there is a market committee or not.
There has to be as per section 13. But
No. Understood. So there is a market committee means as of now, the director has not nominated.
Yes.
Has there been any nomination?
No.
The district agricultural officer Nagaon is holding the post of the chairman. Lordship.
No, that is for the election.
No, my lord, that is not for the election. They have only constituted a one-man committee to run the show.
No, that can't happen.
My lord, that is what the notification says.
No, that is what I've seen. No, to take over the charge of the area
Yes.
as ad hoc chairman.
Yes.
So he only becomes the chairman.
Yes.
If he is only the chairman, can the chairman function in a committee which is otherwise not the chairman of what?
Exactly, my lord. That's why I have impugned.
Let us therefore see where the chairman comes. Let us see. Where is the office of the chairman?
Chairman, my lord. Chairman is in section 10, my lord.
Subject to the provisions of 8, every market shall elect in the member panel one of its members to be the chairman and another member to be the vice chairman. So the power could have been exercised under 8.3.
Yes.
10.3.
No, my lord, but this talks about the functions of a chairman.
No. Whenever for any reason the office of both the chairman and the vice chairman of any market falls vacant, the state government shall appoint anyone from amongst the members of the state market committee as the chairman to hold office such temporarily till a chairman is elected.
Yes.
So this election is to be only in respect to the chairman. Now, are we to understand that whether the other members of the market committee are there or not?
My lord, in my humble understanding, once all the members are elected duly as per section 9, then the members together elect a chairman. So it is amongst them that a person is elected so that they may preside over the meetings.
No, the power, although they may have referred to 48,
Yes.
but isn't this the power which is then under 10.3? It shows temporarily.
But my lord, if I may kindly draw your lordship's attention to section 9.1. 9.1 clearly says that every member of a market committee other than the first one constituted by the state government shall hold office for a period of 3 years, commencing from the date of first meeting of the reconstituted market committee at which a quorum is present. The market committee shall thereafter be reconstituted every 3 years before the expiry of the third year and not earlier than 3 months prior to such expiry. The second subsection. The term
Now,
of
after these 3 years,
yes,
market committee was functioning
yes, it was
till
till the operation of this notification, my lord, till 12/2023.
and what was the term of the market committee?
It was supposed to be 3 years
From
my lord. From 1/10/2018, my lord.
So by 21 it is finished.
Yes, it is. And hence we sought for an extension as per section 9.3.
It's okay.
Yes.
So it is finished.
Yes.
Now where is the power to extend?
Section 9, clause 3, my lord. Clause 3. If I may read, my lord.
But that is only 1 year. 22 finished.
No, my lord. The word here is from time to time direct. The state government may by notification for sufficient cause to be stated therein direct from time to time that the term of office of the members of the market committee be extended by such period not exceeding 1 year as may be specified in the notification. So, my lord, in my humble understanding, when the word time to time is read with 1 year, it perhaps means that at a stretch, they cannot extend it beyond 1 year, but they can extend the same from time to time till the time a fresh committee is duly elected and the chairman is being nominated by the elected members. Because
No, that can't be given. If we give that interpretation out here, the democracy aspect will finish. Tomorrow the state government is in good liaison with this market committee. The state government will keep on increasing. Every 1 year, then there is no election held. Then how do you take care of that situation?
But my lord,
Therefore, they say that you may extend it from time to time, but not exceeding 1 year.
my lord, perhaps this has to be read with section 9 months. Of course, my lord. I'm in agreement.
Because otherwise the democratic setup
Yes.
becomes good.
Yes,
Because
yes.
nobody, then the state government may very well extend. And if it is extended,
My lord.
has the state government extended?
No, my lord.
So under such circumstances, if it is not extended, then when is the market committee?
My lord, we were continuing since our expiry by virtue of the order of this honorable court. Because the honorable court had granted.
How can this court extend?
No, this honorable court had granted status quo order
The
because
second round of litigation, lordship.
because they had
Second
they
round.
had
How can this
Because of
court
this insistence,
exercise this?
lordship,
This is
After
too much.
extension,
But that is not the solution. The solution has to be on the basis of 8-2. Madam,
Yes.
all your justifications doesn't hold good.
yes, madam. I'm so obliged.
Because of
the extension was due to his insistence after.
no,
95
whatever may be,
litigation,
I have not granted any
21,
extension.
lordship.
I have not granted. As of now, there is no market
Kindly
committee.
peruses annexure K and L of the writ petition. lordship.
My lord, the primary point here is that the election should be held in a time bound manner.
Annexure?
K. Till 17/11.
Yes, annexure K is my order. Oh my, yeah. So and extended for Iman has become infructuous because the normal tenure of the lung had expired on Iman and the extended period of one expired date on so and so. As there is no representation, let this matter be listed on so and so. In the event the
After he
petition
was entering the status quo, lordship, there was no representation even before that, annexure K, lordship, before that.
My lord, we
There
had
is no
already submitted a
representation
representation to them.
Till 17/11.
And because they did not
2023,
consider-
due to his insistence, lordship, we couldn't do anything. After that, he has challenged the notification. The a notification of the appointment of the chairman, Lordship, as per section 48.
My lord, my
That is what-
representation is in annexation.
Actually, they have used 48, but it should have been 10-3.
It's a wrong provision, my lord. They could not have exercised that power.
It is whatever may be, but the fact remains what is required to be done is you have to hold the election.
Yes,
Yes,
my lord.
Lordship, that we have to hold, but the
But
petitioner doesn't
this can't be the justification.
Yes, yes, Lordship, that is true. But the petitioner doesn't have any locus standi due to his pursuance, Lordship, because of the litigation, unwanted litigation, Lordship. We couldn't do anything till 17/11/2023.
No, forget about him. I'm not on that. But only this court is continuing with this litigation only for the purpose that you hold the elections
Yes, that is
by
true.
exercising 8-2.
Yes, yes, we have to hold.
You do
That's the
one thing,
election.
you exercise 8-2, hold the elections.
Yes.
If there are no persons out there, because otherwise 8-1 Roman 2 cannot be. As of now, they cannot be
They
because you
cannot
don't
be
give
treated.
license.
Yes, it's noted.
So therefore, the director has to appoint somebody.
Yes.
The director will appoint somebody on their behalf and they will constitute how the market committee will be done. So you may have a market committee out there. We'll have it after 3 months, this matter. You give me an update on that. Because
Lordship, if I can point out, for the election of the marketing committee, for the purpose of conducting election for reconstitution of a marketing committee, there shall be an election authority consisting of the deputy commissioner of the district level head of the corporation department, and the district agricultural officer.
They've
From
already
our department,
elected.
Lordship, it is only at 9A of the rules, Lordship.
no, understood. All these things are how, you see, somebody will elect, who will elect. Now, can there be an election of this 812? 3 to be elected by the
yes, state
traders,
license.
otherwise then the cooperative so-and-so valid license under the act from amongst themselves in the manner prescribed. Now, there cannot be a valid license today because these people cannot collect. They have already been taken note of on this on the basis of a notification of 26/9.
12/6/2020.
29/6/2017. There is a notification of both the central government and the state government to that effect that you cannot collect. In spite of that, they were using it, for which I have passed an order to that effect, they can't do it. However, the refund was not granted, that's a different thing. So they only stopped having the check case from 12/6/2020. And therefore they stopped it. So there cannot be any traders. And they cannot hope of having a traders now unless you come up with some other policy for that purpose. They cannot have a trader. So how do you take care of that? You have to take care by 8-2. On failure of any organization, person or authority to elect any member under subsection 1 within a period of 3 months from the date of occurrence of the vacancy, the director shall give notice in writing to the organization, person or authority concerned to elect the members within a period of 1 month. Now, this may have no relevance in respect to 812 because whom do you issue notice? In order to fulfill this, you have to do, the director has to nominate. That is the only fair reading which can be given.
The director of the marketing board, Lordship.
Whoever it is, the director here, director means what?
The board.
Some director is given, na? The director must be defined somewhere.
Well, it is defined in section 2, clause 11.
Director means an officer not below the rank of additional secretary to the government of Assam having sufficient experience in the EMAN. So there will be some director appointed for that purpose.
My lord, the constitution of the marketing board is in section 3. So it talks about 2-3 directors.
Director, medical.
But as of now, how can there be a chairman? Tell me.
And my lord, they have also constituted an election committee for that purpose way back in 2021.
Understood, but where can there be a chairman? You can have a chairman from amongst the members.
Yes.
Now the members have already spent its force. Unless there is a provision out here in this act saying that till a new committee is not elected, the membership will continue, but that is not here. So under such circumstances, where can there be a chairman? Tell me. The question boils down again back to that square one. There can be a chairman of a committee, provided the committee is in existence. Therefore, 10.3 says, see, whenever any reason the office of the chairman and vice chairman of any market falls, where the state shall appoint one from amongst the members. So now you are actually not appointing a chairman or a ad hoc chairman or anything. What you are doing is having an officer appointed, thereby violating the principle of democracy in this thing. That's your case.
Section 48 then, Lordship.
48, yes, you can do whatever it is, but where is the market committee? Can there be a chairman of a defense? When there is no market committee? And when the act specifically mentions how a chairman can be appointed, and there is category, that is why I'm saying 10.3 also conceives of an ad hoc chairman. See? As the chairman to hold the office as temporarily till a chairman is elected. Meaning an ad hoc chairman till the chairman is elected. But how do you elect somebody, and that has to be elected amongst those persons? But those persons are not there. Who is the question of this ad hoc chairman for what? The sad matter is the state government has now thought it this committee in view of this GST Act has no power. So matter finish. Why should we be bothered with this? Nowadays they don't have money. Have money? He won't say. Because of him, I did not, because of that submission, I did not grant him the refund. He would never say that. He has no money. So, in fact, tomorrow, why you are having this? Remove it. Repeal it. If the central government repealing defunct acts, this is has become a defunct organization. Take instruction whether your state government is going to repeal this act. Because you are not going to do anything to it. And the concept of this having a year means when there is a no market committee, then where is the question of chairman? Isn't it? Mr. A. Bachaji, A. Borua, the learned counsel appearing on behalf of the petitioner. Ms. R. Bora appears on behalf of the Agricultural Department
1, 2, and 3.
of the Government of Assam, and Mr. N.J. Gogoi appears on behalf of the Assam Agriculture Produce Marketing Board. By the instant petition, the petitioner have challenged the appointment of the District Agricultural Officer Nagaon as the ad hoc chairman of the Lanka Regulated Market Committee in view of the expiry of the extended term of the Lanka (RMS).
RMC.
This court had put a specific query upon Ms. R. Bora as to how there could be a chairman or even an ad hoc chairman in respect to a market committee which is not in existence, taking into account Section 10 of the Assam Agricultural Produce Market Act 1972, which mandates that the chairman is to be appointed by the state in respect to a market committee which is in existence. This court also have inquired with Ms. Arbora as to whether the instructions dated 23rd of July 2024, which gives justification as to why the elections could not be held, cannot be held, would be in consonance with Section 8(2) of the Act of 1972. Ms. Arbora submits that she would obtain instructions in this matter and referred back on 23rd of October 2024. List accordingly.
So obliged, ma'am.
Obliged, ma'am.
But there is nothing. I think, Mr. Burwa, why don't you amend your petition a bit? Not amend, file an additional affidavit, bringing into account this. Then how can there be? Because the concept is outside. It has to be done because government, and when the government has been specifically empowered to have a chairman, and how temporarily how, then how can you exercise 48 the residually?
I'm so obliged.
Come up with this.
So obliged.
Yes, what is this?
This is the contempt petition, Lordship. The fact of the case is this, Lordship, the petitioner has constructed a RCC building by taking due NOC and approved plan, Lordship. And thereafter, Lordship, one Hadith Ali, who is the neighbor of.
Where is the respondent?
Earlier they had appeared today.
Yes, Mr. Bigugoi. Well, what is wrong? I don't see Mr. Esbora is not around. Where is he? This is a serious case where I'm about to put the reprimand the people. Yeah. Yes, Mr. Bora.
Also taking up the writ petition also.
Yes, repetition, I'll take it.
There is a subsequent development because the issue raised here is that the notice issued in a Secretarial 1 and 2 is without jurisdiction. And the law court has also allowed us to revisit that particular notice. So we have revisited and found that the notice itself is without jurisdiction because it was signed by the additional commissioner. So ultimately, whether that notice was recalled. It should have been by the because it violates the section 37 of the GMC Act. That was the contention.
When did you take steps for demolishing?
Petition was done
On 4/3/20. 4/3, Lord.
4/3/23.
3/23.
4/3/23.
This document is already there, page 61 of the contempt case.
Yeah. Thereafter a fresh notice was issued. Fresh notice was issued on 15/2/23 by the commissioner. Because the commissioner is there. 15/2. Lordship will find the contempt petition page number 62 and it's 18.
Then did they reply?
No, they didn't reply. Nothing was replied. No, they replied, my lord, the notice.
22/2. 22/2.
15/2 is the notice. It had a 1 and 2 notice.
I have already submitted your good self with all the necessary documents regarding the building permission situated at Friendsport Iman. We have already explained in detail in the said reply dated here to the Honorable Mayor so and so under what circumstance I have to construct a with minor deviations from our side. I did the construction in my residential building. I, as a law-abiding citizen, has constructed the area without hampering any of the locality. If the above order is executed and I am ready to compensate the authority by way of fine if I have done any mistake regarding construction of Iman. A person intend directly not to demolish any structure to the staying of operation of Iman in the disposal of Iman on Iman before the Iman. please find herewith a copy of the order, but the said appeal is still pending for disposal. Regarding granted stay till disposal of the appeal as such, the notice is uncalled for and improper. Then what do you do with the reply?
My lord, thereafter, my lord, you will find a final notice with it has a 337 A1 and it has given 3, my lord. Final notice at page number 67.
Page 67.
67.
On receipt of the above notice, you have submitted your reply. Subsequently, a site inspection was done by the concerned demand. Under the said instruction and demand, it is ordered that to remove or pull down the said unauthorized construction as per Schedule A of the scheme as found. What is deviation from the approved plan? How much is the deviation?
There is a lordship will find that column, my lord.
Hmm.
Right hand side column, my lord. Deviation, all the frontage, they are all.
Approved 450,
There is a
maintain
non-com-
5
these are
and
three
3
sides are non-compoundable.
setback.
One is
Deviation 0 and 0.80. Rear 180, maintain 0. Deviation 180. East 180, 125 Iman. So on the rear, there is no setback.
No setback. Lordship will find that page number 67, the demolition exercise. Page 67, the photograph. My one is black and white, my lord. But there is some small soap and some bathroom latrines where
68.
60, my one is 66, my lord. This black and white photograph. These are the demolition exercises that taken place on 4/3.
Then
That's all only.
but what stopped you from taking the permission from the court? What is the so urgency that there was a requirement of demolishing of such?
Well, we found it out there that
Understood,
we have been a
very good.
mistake. We have been a mistake because regarding that exercise of violation of 37 from the additional commissioner. Then commissioner issued my lord thereafter the
Because he in his reply stated about the High Court's order.
High Court. But High Court also gave the liberty to revisit the notice. We revisited it. Thereafter, we also served it. Then the process. This is a fresh notice. Freshness is the process has also started, my lord.
Did you file your affidavit in this matter, the other petition?
No, this has become infectious. The moment we have recalled the entire petition has become infectious.
Whereas Hadis Ali submitted complaint against Sanu on the illegal construction and road encroachment, whereas so-and-so was asked to produce, whereas the service Iman so-and-so approving deviation of the Iman as notice on the so-and-so, reply submission is not in the now therefore of the representation submitted by Mohammed Sanu on Iman, the necessary action is for GMC for unauthorized use. Why do you say that 16/12/2022 is beyond jurisdiction?
First notice, lordship.
Ah.
Because it was signed by the additional commissioner. It should have been signed by the commissioner.
Now, kindly come to page 53 of the earlier of the writ petition. This was put to challenge.
This was challenged because it was challenged.
This
Because
is
it
by
has
the
law-
commissioner.
No. This is by the commissioner, but it was because the main notice, 337, that is the point of challenge. The inception of the notice is by a additional commissioner, deputy commissioner.
That was the
By the
ground.
additional commissioner, that violates section 37 of the GMC Act. You cannot issue a notice. That is the reason my lord court gave a liberty to revisit.
So, Mr. Roy, your construction was legal?
Admitted, my lord, in a notice issue, he had.
Construction was illegally regarding the front portion, lordship. There were two shops were constructed by the petitioner, lordship. So upon service of the first demolition, so-called notice, lordship, we had demolition. That's why in the second demolition notice, lordship, front margin, they have, there is no deviation, lordship, page 67. There is no deviation. Front, your lordship will find
Page 67
page 67
of the contempt.
of the content.
Yes.
There is no deviation, lordship. Then regarding rear, there is a 1.80 deviation has been shown, east only 0.55 meter, which is a compoundable, lordship, as per the GMC. And the west,
Front side is not, front is 0. Deviation and 0.80.
that is
Compoundable.
0.880 is compoundable, lordship, but they have written it non-compoundable, which is
Is
not
it compoundable?
Uh,
How much is the compoundable? 10%.
There is a calculation, my lord, according to appendix 3, my lord. That calculation has to be done.
Is it compoundable?
But it is the notice itself says not compoundable.
Huh?
It is a notice says not non-compoundable. Because appendix 3 had to be applied. After after applying the appendix 3, this notice has been given.
Where's your affidavit here?
In the contempt, sir. Yes, contempt I have filed my affidavit, my lord. It starts from page number, running page number 69. The 11th paragraph starts from paragraph number 12.
And his appeal was directed against that notice without jurisdiction.
Appeal should not have been filed because not a final, it's a so-called notice, you cannot find an appeal under section 398. They have just placed it, it was not even registered.
No, but whatever may be, the appeal was on the
Against
ground that he had no jurisdiction.
notice, that is earlier notice dated 21/10/22.
that is not the correct legal position, lordship. Even against so-called notice, appeal can be filed under section 438 of the GMC Act. Even if a so-called notice is issued, appeal can be filed. Lordship, be pleased to peruse the section 438. Any order or notice or letter issued by the commissioner, appeal will be.
I'm not on that. I'm not on that. I'm saying what is the ground of appeal? What was the ground of appeal? Was it the jurisdiction point which was challenged?
We have taken the plea that the additional commissioner of the GMC, lordship, does not have any power to issue any.
Therefore, your question was on the question of jurisdiction of that, of the issue.
Official, because lordship, section 37 of the GMC Act provides the delegation of the power by the commissioner to the subordinate officers, lords. But that delegation power has not been given to a subordinate officer, lordship, under section 37 of the GMC Act regarding issuing the notice under section 337. Fact of the case is entirely different, lords. When the first notice was issued, lordship, I had preferred an appeal. Then the appeal was not registered, no order was passed. Repeatedly, I had visited the office of the standing appeal committee.
No, when you got that notice and you replied, why didn't you move this court?
Lordship, they had treated to demolish.
You were issued a notice on 15/2/2023. You replied on 22/2/2023. They passed the order on 3/3/2023, and the demolition must have happened subsequent.
4/3. 4/3/20.
4/3.
Notice was issued on 3/3. Only Lordship, after demolition, the notice dated 4/3/23 was given to the.
No, not notice, that's an order.
Final notice.
It's an order being given. But why didn't you approach this court on 15th when you got the?
Lordship, when the appellate also, when I filed a statutory appeal, Lordship, then the standing committee was not passing any order, Lordship. So that was also one of the ground, because a statutory authority cannot sit over. My learned friend has submitted that no appeal is maintainable under section, if a so cause notice is issued under section.
I'm not on that. Well, he may say on that, but I am asking you, when you received the notice on 15/2, that they are now going to take an action like this, why didn't you approach and file an IA in this petition? That you see what they are doing. Huh?
I filed.
Face notice.
No, Lordship, please to peruse the second notice.
Huh?
Lordship, this submission of the contemner is this, Lordship. When the first notice was issued, demolition notice was issued by the additional commissioner, Lordship. I took the plea that additional commissioner cannot issue any such notice. Then they had recalled that notice. Then Lordship, and the second demolition notice was given on the basis of the so-called notice which was given earlier, Lordship. So when the notice which was issued by the additional commissioner withdrawn, recalled, then so-called will also go, Lordship. When Lordship, the additional deputy commissioner had issued a notice under section 337, I had filed my appeal. That 337.
Understood. Let us go. That has been recalled. Then what happens?
No, that is the main point here, Lordship. Lordship, please to peruse. Come to page Lordship 62.
No, I'm not on that. Why have you not approached this court by filing an IA? Then look here what they are doing.
Lordship, because the earlier, when the first.
When you have passed an order, now they are doing this.
No,
Why haven't you approached?
In the writ petition, this honorable court passed an order that no demolition will be done by the respondent till the disposal of the appeal filed by the petitioner. Lordship, please to peruse the order of the Honorable High Court. So I was under the impression that the appeal is pending. Page 54. Page 54.
As an interim measure till the returnable day, it is provided that till the disposal of the appeal filed by the petitioner on demand before the standing committee, the respondent authorities, that is the state, shall not demolish the structure of the petitioner which is pursuant to the notice dated so and so. An operation of the order dated demand is stayed till the disposal of the appeal. Having regard to the grievance in here, this court also inclined to provide that the pendency shall not be a bar to the competent authorities to revisit the order dated so and so, passed by the additional if so advised.
So Lordship, appeal is still pending. Neither it has been rejected, nor any hearing has been done, no notice for hearing has been done. So the petitioner was under the impression that as the appeal is pending, so there is no need to file. Lordship, the second.
So if the petitioner can be under the impression, why can't they also be under the impression?
No, Lordship,
Look here, the court has given this liberty, so we have exercised that liberty, we have recalled the proceedings, and now we have issued a.
Lordship, please to consider whenever a.
No, therefore the question is whether it is a case of willful and deliberate. We don't exercise our jurisdiction unless it is a willful or deliberate.
Lordship, here my submission is this, Lordship. When the second demolition notice was issued, Lordship, please to peruse, page 62. because this notice was issued, Lordship, page 62, without issuing any show cause notice. Lordship, be pleased to consider that when the first demolition notice was recalled by the GMC Lordship, the earlier show cause notice will also go.
No. Whether prior to show cause notice, there is a requirement of issuance of a notice.
Prior to issuance of the show cause notice.
There is a requirement of
Lord.
issuing a
My
notice.
submission is this: when the final second, when the second demolition notice was issued, they have referred that consider on the basis of the Lordship in notice page 67, 67. The notice under section 337(1) and 2 were served to you by GPL number so and so dated 15/2/28, asking to discontinue the undertaken works, erection, this and that, Lordship. So this gives reference to the Lordship notice dated 15/2, that is, which was issued when the first demolition notice was. Now,
Mr. Roy, either you have not studied the matter properly, don't come up with these type of submissions. Kindly come to page 62. The order passed by this court was earlier to that. You have challenged 21/2/2022 order in that petition.
Yes, that was
Then
recalled.
that is there. Then the court gave them that if you want to take a revisit, you can revisit. And accordingly, what they did on 10/2/2023, they cancelled the earlier notice and then came up with a 15/2/2023. This is a show cause notice, and you replied on 22/2/23. My specific question, Mr. Roy, is as to whether in a case you have, why didn't you approach when this notice of 15/2/2023 was issued before this court? That look here, this is what has happened. Because there was you see, the question is initiation of contempt proceedings can happen only at the time when there is a willful and deliberate violation. Now, can this be a case of willful and deliberate violation when there was? I would have understood if the last part of that order was not there. The revisiting the permission being given and they have revisited. There the problem arises.
When the first demolition notice was recalled, and when the second demolition was noticed, they have relied upon the Lordship, the show cause notice dated 17/9/22.
Where?
Page 62.
Documents asking notice was served. This is the different.
The documents asking notice was served.
This is not 337.
No, Lordship, please to come to page, Lordship.
And
62.
anyway, we are not
Page
on a
62.
repetition. This is a notice on the the instant heard
Lordship,
Mr.
please
SP Roy, the
to
learned counsel appearing on
page
behalf of the
62 is a show
petitioner.
cause notice.
Mr. Ezra appears on behalf of the respondents. The instant contempt proceedings have been filed challenging the alleging willful and deliberate violation to the order passed by this court dated 10/1/2023 in WPC number 8460/2022. From a perusal of the materials on record, it transpires that on 16/12/2022, a notice was issued to the petitioner stating that the action
Your Lordship, please to peruse once page 62. This is just notice under section 337.
on 21/10/2022, a notice was issued under a notice was issued under section 337 bracket 1 and 2 of the GMC Act of the Guwahati Municipal Corporation Act 1973, for short the GMC Act. In pursuance to the said, an order was passed on 16/12/2022. On 21/10/2022, a show cause notice was issued by the Additional Commissioner of GMC under section 337(1) and 2 of the Guwahati Municipal Corporation Act 1971, for short the Act of 1971. In pursuance to that, the Commissioner GMC had passed an order on 16/12/2022. Footstep. The petitioner being aggrieved by the issuance of the show cause notice dated 21/10/2022 by the Additional Deputy Commissioner GMC had filed an appeal before the Chairman's Standing Appeal Committee, which was received on 3/11/2022. Be that as it may, as the order was passed thereafter on 16/12/2022 by the Commissioner of Guwahati Municipal Corporation, the petitioner filed a writ petition being WPC number 8460/2022. In the said, this court, by an order dated 10/1/2023, issued notice making it returnable by 4 weeks. As an interim measure, this court directed that till the returnable date, it was provided that till the disposal of the appeal filed by the petitioner on 3/11/2022 before the Standing Appeal Committee, the respondent authorities under the Guwahati Municipal Corporation shall not demolish the structures of the petitioner, which is pursuant to the impugned order dated 16/12/2022, and the operation of the order dated 16/12/2022 was stayed till the disposal of the appeal. This court further, by the said order dated 10/1/2023, granted liberty to the competent authority of the Guwahati Municipal Corporation to revisit the order dated 21/10/2022, passed by the Additional Commissioner GMC, if so advised. The relevant portion of the said order dated 10/1/2023 being relevant is reproduced hereunder. Yes, can you have page 55 of it? My tick my codes. Issue notice returnable by 4 weeks of a list the matter after 4 weeks. Page yet 59 of the 59/6. Thereupon, as the liberty was granted to the competent authority of the Guwahati Municipal Corporation, the Commissioner GMC, by an order dated 10/2/2023, recalled the notice dated 21/10/2022. Subsequent thereto, on 15/2/2023, a show cause notice was issued by the Commissioner GMC alleging that there has been certain violations, deviations from the approved plan in respect to the front area covered with 2 shops and setback deviations. The petitioner was asked to show cause within 7 days as to why the said unauthorized construction should not be demolished or sealed. The petitioner submitted a reply on 22/2/2023. Wherein the petitioner informed about the pendency of the writ petition being WPC number 8460/2022, as well as the order dated 10/1/2023 passed therein. It was also mentioned that the petitioner was ready to compensate the authority by way of fine if there was any mistake regarding construction of the building. He also submitted that he had demolished the 2 numbers of stops in front of the RCC building. Thereupon, an order was passed on 3/3/2023, whereby it was mentioned that the divisions in respect to the front, rear, and the west side were non-compoundable. It has been further mentioned that on 4/3/2023, the demolition was carried out. The petitioner being aggrieved, the petitioner thereupon has approached this court filing the instant contempt application, alleging that there has been a willful and deliberate violation to the order dated 10/1/2023 on the ground that there was a direction not to demolish the structures of the petitioner. Pursuant to the notice being issued, the respondent has filed an affidavit wherein the stand which have been taken is that there is no willful, intentional, or deliberate violation or disobedience to the order passed by this court. It was further mentioned in paragraph number 12 that the show cause notice dated 21/10/2022 was cancelled or recalled by the order dated 10/2/2023, and thereby the appeal so filed under section 438 of the Act of 1971 on 3/11/2022 had become redundant. In addition to that, it has been mentioned that thereupon a show cause notice was issued under section 337 bracket 1 and 2 of the Act of 1971 dated 15 to 2023, which is a completely fresh cause of action. It was also mentioned that a reply was submitted on 22 to 2023 to the show cause notice under section to the show cause notice. And thereupon, an order was passed on 3/3/2023. In addition to that, it is seen that it is the stand taken by the respondent that the action so taken was on the bona fide belief that the petitioner, that the respondent authorities were given the liberty in view of the penultimate paragraph of the order dated 10/1/2023. It is also mentioned that if for any bona fide act, the order dated 10/1/2023 passed in WPC number 8460/2022 had been violated in any manner, the respondent had tendered his unconditional apology. First, this court have duly heard the learned counsel appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondent. And have duly given the anxious consideration to the respective submissions. The question therefore arises as to whether this is a fit case for initiation of contempt proceedings against the respondent. It is seen from the order dated 10/1/2023 that the petitioner had challenged the order dated 16/12/2022 passed by the commissioner, GMC, on the ground that an appeal had been prepared against the notice dated 21/10/2022 issued by the Additional Commissioner, Guwahati Municipal Corporation, which was pending before the Standing Appeal Committee. It is under such circumstances, taking into account that on one hand an appeal is prepared, and on the other hand, the order dated 16/12/2022 was passed. This court directed that till the disposal of the appeal filed by the petitioner on 3/11/2022, the respondent authorities under the Guwahati Municipal Corporation shall not demolish the structures of the petitioner, which is pursuant to the order dated 16/12/2022, and the operation of the order dated 16/12/2022 was stayed till the disposal of the appeal. It is also to be noted that this court granted the liberty to the competent authorities of the Guwahati Municipal Corporation to revisit the notice dated 21/12/2022 passed by the Additional Commissioner of the GMC, if so advised. By the order dated 10/2/2023, the notice dated 21/10/2022 was withdrawn. Upon withdrawal of the said notice dated 21/10/2022, all fallout actions, including the order dated 16/12/2022, had become redundant. It is also to be taken note of that with the order dated, with the withdrawal of the notice dated 21/10/2022, the appeal which was filed against the said notice had also become infructuous. This court have also taken note of that pursuant to the notice, withdrawal of the notice dated 21/10/2022, the petitioner was issued a show cause notice on 15/2/2023. The petitioner thereupon did not approach this court by filing any interlocutory application. Rather, submitted a reply on 22/2/2023. And thereupon, the order was passed on 3/3/2023. It is also to be taken note of that all these actions were taken on the basis of the liberty so granted to the respondent authorities by the order dated 10/1/2023. It is also to be borne in mind that the direction not to demolish the structures was on the basis of the order dated 16/12/2022. And as such, as the demolition was not in pursuance to the order dated 16/12/2022, but on the basis of the order dated 3/3/2023. This court is of the opinion that the same would not come within the ambit of a willful and deliberate violation of the orders passed by this court. Accordingly, this court finds no merit in the instant contempt proceedings for which the same contempt proceedings stands dropped. Taking into account that the order has been passed in 3/3 order passed on 3/3/2000 year by the GMC and the construction alleged and the construction taking into account that pursuant the order dated 16/2/2022 having become redundant in view of the withdrawal of the notice dated 21/10/2022, nothing really survives in the instant proceedings. Accordingly, the petition stands closed.
Because the petitioner is above 80 plus, my lord, he was unable to go for a commission to execute the sale deed because he want to get his lands sold for its better treatment. He filed an application for commission, which was refused verbally. That is why I am before your lordship. My lord, section 38 of the Registration Act and this notification, your lordship can peruse this notification. This writ petition along with everything was also done in Borak Valley, my lord. I got the affidavit done there only.
Yes, madam, why you are not permitting? What is wrong?
I'll obtain instructions.
Get it done.
Can it be by next Monday because he's want to go for a treatment by selling the plot of land? He is 80 plus and having a serious problem. Or your lordship may dispose of the matter, consider the representation and pass orders in according to section 38 of the Registration Act.
Absolutely no. Issue notice making it returnable on 19th of September 2024. Miss Revenue? No revenue. Ms. M. Hazarika appears on behalf of the respondent number 1 and 2. Ms. S. Sharma appears on behalf of the respondent number 3, 4, and 5. The petitioner herein is aggrieved by the inaction on the part of the. I am not making the sub-register a party. I made the sub-register a party. Because the sub-register is the person who does it.
No.
Huh? Aggrieved by the inaction on the part of the sub-registry of Karimganj in not exercising its jurisdiction conferred upon it by law of permitting the execution of the deed of sale by way of commission. It is seen from the records that the petitioner is 80 years old. And the materials also show that the petitioner is suffering from various ailments. And under such circumstances, the petitioner, on account of being ill and bedridden, had requested that the execution of the sale deed be done through a commission at his residence. This representation was submitted on 9/8/2024. However, there is no steps being taken by the concerned respondent authorities, and it is under such circumstances that the instant writ petition has been filed. This court, upon perusal of the materials on record, is of the opinion that on the basis of the order dated, is of the opinion that the petitioner, being a senior citizen, being an elderly senior citizen of the age of 80 years and having and suffering various ailments, the respondent authorities ought to have taken into consideration the prayer of the petitioner. Under such circumstances, this court takes instructions from the respondent number 4 and 5, including the sub-register of the Karimganj sub-registry, as to why the petitioner's request for commission, request for execution of the deed of sale by way of commission is not being permitted. A copy of the certified copy of this order be served upon the it is, however, made clear that the petitioner, in the meantime, it is, however, made clear that upon submission of the certified copy of the instant order to the district register Karimganj as well as the sub-register Karimganj, the said officials, it shall not be a bar on the part of the said officials to complete the registration through by issuing necessary commission. Also, Madam, inform.
Yes.
Get it done. But Mr. P.K. Roy Chaudhary, you have done so many matters out here. Who does the registration? Tell me. Whom do you file as a commission application? Is this type of a repetition you file?
I understand that there was a mistake.
Goodness.
Sub-register is the person.
Then you should
Senior
you make
sub-register?
the request to the sub-register. Have you ever heard of? making it to the district administration.
The senior sub-registrar.
And you are making, whoever you want to make a party, why you are making the commissioner and secretary revenue a party?
May I please, Madam? But this application, the first application, which is company petition 6 of 2014. This was filed under section 468 of the old act, my lord, Companies Act 1956, seeking books of record and assets. And now whatever was with the director, they have submitted to the official liquidator. He had in fact filed a report. The report came directly to the registry, my lord. They have placed that flag X I've seen in the file, my lord. Flag X1. The first flag. Most of the assets were taken by the secured creditors. A little bit of cash in hand was left, which they have transferred by draft to the official liquidator. And also, therefore, as such, there's nothing remains in this application anymore. Because whatever directions that we sought, directors have now given to the official liquidator.
Huh? What remains?
Nothing remains as such.
We close it.
Yes, ma'am.
Taking into account this court heard Mr. A. Sandillo, the learned counsel, appearing on behalf of the official liquidator. This court have also perused the report dated 27/8/2024, furnished provided by the official liquidator of the Guwahati High Court. Now these people have got money.
I know that process has not even started because of there were two applications pending to this court, one under 454 for statement and record, and one this application. The 454 details were submitted by the director, so that was closed. This chapter was still going on. So now, since they've given whatever else was necessary, he can start proceeding in collating claims. In fact, the other application.
Now, do I need to close this or keep it?
Well, my lord, this may be closed because they have now complied with whatever was required to have to be given to the
What
OS.
was the last order, sir?
That report only was pending, my lord. If the official liquidator is satisfied with the documents submitted by the directors, that is why now he's given this report.
Yes, Mr. Bapujari, what is to be done?
Has to be closed, my lord, because the company is in liquidation and the respondents out here whom I am representing, they are the erstwhile directors of the company in liquidation. All the formalities have been complied with. Now the ball is in the court of the official liquidator. And he says that
This court have also taken note of the report dated so and so submitted by the official liquidator of the Guwahati High Court. According, nothing further survives in the instant proceedings. The official liquidator Guwahati High Court shall now proceed on the basis of the same report dated 27/8/2024. The instant proceedings accordingly stands disposed. Both.
I'm so obliged.
Item 32.
This petition, the petitioner.
Yes, what is this?
My lord, order dated 25/11/2019.
25?
11/2019. My lord, the prior respondent.
25/11/2019.
Page
51.
25, page 25.
Oh, yes, this one. What remains?
My lord, actually, my lord, the prior respondent, my lord, the
You are
petitioner-
challenging what?
This order, my lord, because this order was now passed without considering my objection, my lord. This order says that I made no objection. In spite of the fact, my lord, I filed written objection, my lord. But
Oh, yes, yes, yes. Where is that order?
page 25, my lord.
Huh?
Page 25.
First party so and so, Iman, an application was filed in here. The revenue cycle has submitted a report according to so and so. To deposit 65 month. There is.
My objection is, my lord, page 9.
Show me the records. You've seen it, whether there is an objection or not.
It is not.
Huh?
Objection is not there on the record.
What are your name?
My lord, my name is Khagen Sundar Meddi, my lord. Khagen Sundar Meddi and Withdrawal Meddi. Notice was issued on page 18. Notice was issued in my name.
So here, the records, it doesn't show that you have submitted none of the orders also
But
show.
my lord, in affidavit, they admitted. Affidavit in a position that the deputy commissioner admitted that he considered my objection. My lord.
Huh?
In the affidavit filed in the petition, my lord,
Huh?
the deputy commissioner admitted that he has considered my objection.
How? Where?
My lord, page 38, para 4, my lord. 4A, my lord.
How do this person say so? This person Kailash Kartik, was he the person concerned? He was not the person.
He is the deputy commissioner.
Understood. He may be the deputy commissioner, but on what basis does he say?
Additional deputy
And that too true to his knowledge.
in the,
How can that be true to his knowledge?
yes,
Was he the person who signed it? He was not the person who actually did it. How could this type of affidavit be filed by these people? Who was the person? Upayukta. You see, there are 3 orders. First is the notice being given on 14/11/2019, wherein it has been said, শুনানিৰ বাবে আদালতত উপস্থিত থাকিবলৈ জনোৱা হওক। কাৰ্যত 20/11/19।
20th, my lord,
Then 2011,
they filed the Hajira. but
you no, and the দ্বিতীয় পক্ষ এই হৈ ব্যক্তিৰ অধিবক্তা হাজিৰ দাখিল কৰে যদিও গোচৰ হোৱা সময়ত অনুপস্থিত থাকে। গোচৰৰ শুনানিৰ বাবে অহা ইমান ধাৰ্য হওক। Then 25/11, that is the order. The record does not show. What
25
basis does he file the affidavit, that person?
my lord, on 25 we filed objection. On 25 we filed objection.
But that is not recorded. There is no matter is not on records. How do you say so that it was filed?
But it was filed, my lord.
Huh?
It was filed.
How do I know? Why you are not filing an appeal against these type of things?
My lord, when this order was passed, then on the subsequently, my lord, we filed an application before the deputy commissioner, my lord, that our objections are not considered. That application is, my lord, at page 29, my lord. Then, my lord, we were told that the record is not traceable, my lord, and they put up a notice, my lord, which is at page 34, that the record is not traceable. So that application was not taken up.
Who is appealing for the respondents?
I'm receiving.
Huh?
So far, the appeal provision is also there regarding the maintainability of the petition. So far, section 67 of the Act provides. You would have approached it for the revenue board.
But Mr. Gore, how do I take care of that when the record does not show so? There is any objection. How do I take care of that?
But my lord, in my subsequent application also, my lord, I raised this point and they told me that record is not traceable. And this fact has also not been denied by them. My lord. And the others, private respondents are also not denied this fact. My lord. They were also there. Then I filed the objection. And secondly, my lord, there are other violations, my lord. They have to comply rule 9, 10, and 11 of, my lord, they said temporarily settled areas tenancy act, my lord. That was also not complied with, my lord. So the appeal provision is there, my lord. But if they fail to comply with the provision, my lord, then I can approach this, my lord.
No, understood. No, I also want that let it be matter be remanded back. But how give me a thing if it is on the basis of when the records does not say the earlier order also there is no objection filed. You filed on 25/11.
Yes, yeah, I.
25/11, where is your receipt?
Oh, receipt.
And the order was passed on 25/11. Did you go and check where it has been mentioned? And why did you file the petition in 2021?
But I was waiting there, my lord, that.
But 2019, that order was
No,
passed.
no, in the, my lord, very immediately thereafter, my lord, I filed this application. I was after, my lord, on 26 or 27, 11/2019, I filed the petition my lord, that my objection are not considered. But I was told that the record is not traceable, my lord. So I waited for, my lord, all this period, my lord. When I failed to, I came that there may be something wrong in the record, then I approached this on the court. I also applied for certified copy also, my lord. Certified copy was also not provided, my lord.
Certificate. Sorry, certificate copy, yes. Certificate copy, this is provide for an idea.
25/11. And this fact is also admitted that record are not traceable, my lord. In the affidavit, the fact that the record was not traceable, that is also admitted by them. Because they shifted their office from, my lord, the old building to new building. So they say that the record was not traceable at that point of time.
For the order being silenced by them, this is the certified copy. I have seen.
So do one thing, records are already there. You see, we'll have it on 19th at the top of the list. Produce the records. This matter having been heard at length, it's the matter on 19th of September 2024. At the top of the list, Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondents, shall produce the records again.
May I seek an indulgence for a second?
Yes, yes.
I was sitting since 10:30, but I have been cheated by my mischievous work. I don't want to have a chip of water. The 30 and 31, that has been disposed of by your lordship. Both of the cases disposed of, 30 and 31 number. Company appeal.
Disposed.
May I, ask your lordship that at least
Huh?
my name may kindly be
Okay, you are appearing for whom?
NBCs. NBCs.
31.
Okay, ask your, you have to give the name. We'll put out there. I have not put anybody's name out there. I've just put the name. I have only said that it will be closed in view of this. The official liquidator shall proceed on the basis of the report.
Not submitted any report for 6 years.
And they have now done it.
My lord, in this matter, my lord, item 33, I have received some instruction today, my lord. I'd like to file one affidavit, my lord.
Okay, Mr. S. Dotto, appearing on behalf of the PNAD department, submits that he has already received the instructions. What is the instruction?
My lord.
Whether the petitioner is entitled to the amount so claimed, and if so, why the amount has not been paid. That is the only instruction.
Yes, my lord. We are examining, actually, it's the fault of the video, my lord. Now, not only this case, my lord, there are numbers of cases where because of the video's fault, my lord, petitioners are suffering, my lord. Therefore, we are now, my lord, take up the matter with the government of India. For if they will not release, my lord, we have to take action against video, and for recovering after them, my lord, we have to pay the petitioners.
Why the video isn't it under your official?
Yes, my lord, but these are the central government schemes, my lord. We are just implementation.
But video is your official.
Video is the program officer, my lord.
Of yours. Under the
Yes, yes,
panchayat, and
yes.
then why you are not able to take action?
My lord, because we are just taking this matter with the government of India because it's government of India scheme, my lord. Therefore, if government of India will say that the money will not release, my lord, because of the BDO's fault, then we will take action directly against the BDO's. And we have to recover the money from the BDO.
How do you recover? How will you pay?
That the government is examining.
And this is not for a small amount, 692.52
Now,
lakhs.
not this is the single case, my lord. There are other cases also, my lord.
That is why the total allocated fund is 692.52
Yes,
lakhs.
that is why government is examining, my lord, because totally fault of the BDO, my lord. Did and BDO, my lord. Last paragraph maybe.
Mr. S. Dutta submitted that he has received certain instructions wherein it has been mentioned that the Commissioner PNRD Assam have been reviewing the matter relating to the pending material bills and have communicated to the Ministry of Rural Development, Government of Assam,
Government of India, man.
Government of India. As such, he submitted some time would be required. Be that as it may, this court, however, takes note of that the instructions sought for by this court have not been placed, whereby placed inasmuch as this court, by the order dated 16/8/2024, directed the respondent PNRD department to file an affidavit as to whether the petitioner is entitled to the amount so claimed, and if so, why the said amount has not been paid. The respondent PNRD department shall, by way of an affidavit, inform this court as to whether the petitioner is entitled to the amount so claimed. This matter again on 28/10/2024, on which date the respondent PNRD department shall file the affidavit without fail.
Fine. I'll tell you.
On or before which date the respondent PNRD.
Before.
Yes, I have filed affidavit in the reply.
Huh? You filed the reply?
Yes. We have the petition.
Now what do you want?
Granted the PDS license.
Insert the license code of the petitioner in the RCMS immediate and code of office. Now,
Lordship, there is a more than 100 beneficiaries under the scope of the present petition.
what is the respondent's state?
Lordship, they tagged the beneficiaries
Requesting
with the
the
nearest.
take necessary except for inserting the demand in money manner for inserting the license on the demand in respect to the above mentioned method. Could not be inserted in the government authorities. So you cannot be given in view of the present scenario of one nation card.
Yes, Lordship, kindly,
Chalo, we have it sometime after vacation.
page 21 of their affidavit.
Mr. Counsel,
Paragraph four,
oh,
Lordship.
you, how many people are there?
More than 100 Lordship. They cannot be tagged Lordship.
For the time being, possibly they have been tagged with some other.
Huh?
We have said in paragraph 4 of our affidavit. So and so have already been tagged with the nearest FP shop so that they could get the government benefit on time.
But he says that he has more than 100.
Yes.
That was
Mr. B.J. Talukdar, the learned counsel appearing on behalf of the petitioner, our respondent shall obtain instructions in view of paragraph 6 and 7 of the affidavit in reply filed by the petitioner. Wherein it has been mentioned that the petitioner has more than 100 beneficiaries tagged to her shop. And as such, the the reasons were assigned in the affidavit in opposition cannot be applied insofar as the case of the petitioner. Full stop. List the matter again on 23rd of October 2024, on which date Mr. B.J. Talukdar shall obtain the necessary instructions. You see, more than 50, you have to give. Why you are not giving? You bring by way of an additional affidavit, you have it, those details.
Yes, this court judgment I have passed by your lordship on judgment that as per categorically stated lordship. I have the order.
No, it's okay, but you just find out.
Yes.
Yes, what is this?
May I please your lordship. In this case.
Victim compensation.
Yes, boss.
Then
I have a similar situation matter already your lordship discussed.
my order.
Order code, yes.
Good. Award passed, madam.
Interim award 1,25,000 because the trial was pending and in terms of section 5(3), the DLSA had given 1,25,000.
But the question is that there is a death, a crime has been committed. I still remember the judgment of the Justice Bhuyas,
Yes,
yes, wherein it has been said, irrespective of all these things, whether proof or not, a crime have been committed,
Yes.
and the person is required to get.
Lordships have also observed in several cases.
Huh?
Lordships have also observed in 2 or 3 cases, to my knowledge.
Yes,
Similar lines.
on the basis of the AR, it appears that the petitioner will come
We
within the
find
ambit of
affidavit.
claim 1. Now, what has happened here? Who are you, petitioner number 1?
Wife of the deceased.
Huh?
Wife. Wife and
Who died?
wife and son of the
Wife
deceased,
and
your lordship.
son. The son is minor.
Minor, not minor.
Yeah, okay, yeah. Yeah, was murdered. Who is murdered?
Kamleshwar Deka.
Was murdered. And yeah, they filed an application dated so and so. Okay, to dispose of something. Look, upon facts to silence, dispose.
So blessed.
Yes, focus has not been.
No.
They said, well, this is the procedure they are following, madam. And my lord, that was not issue. That's why probably, my lord, in the last paragraph, we have stated that if opportunity is given, we will again.
But how do I give? Now?
Otherwise, my lord, because the form also I checked, but rule 142.
Order passed when? Order was passed within time.
On 25/12/23.
25/12/2023.
Also time bound.
Huh?
Time bound, madam. 1718 in respect. of-
Why? Now, why did you approach late, so late? You thought?
But it was uploaded.
Don't worry, we dismiss your petition on that ground. When there is a challenge, Mr. B. Gogoi,
Well,
the law is very clear to the effect that if there is a challenge or moved under writ petition, it has to be moved within the time limit. Permissible. Otherwise, I can't entertain. Isn't it?
well,
Then why didn't you move it earlier? Why didn't you move it? Why did you wait all this while? Tell me. Why did you move in 70?
When it was received, that I don't know.
Huh? You
When
can't
she-
say that you don't
We
know.
don't-
It is there in the portal. There in the portal. Then how can this court then now say that he is entitled to a year? Tell me. If there is just for example, there is an illegality in a 73(1) proceedings, there's some illegality, some notice was not properly done. In the meantime, the petition was filed and the matter has been pending, and after 4 years, this is disposed of. Now, when you say that the matter is become infructuous,
So far as my lord, this assessment is 17 and 18, your lordship. And proceeding is required to be initiated after serving me notice, my lord. That has not been done, and my lord.
therefore, I'm saying, why didn't you approach this court within
what-
time? When the order was passed,
Order
was
was
the order
on
passed within time?
25/12/2023.
Huh?
Order date is my lord 25/12/2023, page 38.
And the order was passed 38. (25/12). This is within time as per 5, as per the 9. This 17/18.
17/18, section 17.
So it is time within time as per notification 9.
State GST. State GST.
Wow. State GST, what to do?
That again, will be then considered on 17, that aspect.
Apparently, admittedly, Soko's notice has
Yes,
not
but-
been.
But one thing, moment he has got this particular summary at page 28, on 28/9/23, he should have followed approach the honorable court, that without the so cause, this summary has been,
Which one?
page 28. Summary of so cause. He shall be the ground, but he remains silent and at all there is the illegality. At least he should have written some application to the authority seeking a copy of the so cause notice. If at all he was serious.
The foundation of the case is Soko's my lord. And as per subsection 4 of section 75, my lord, if the adverse order is passed, my lord, an opportunity of being heard should be given before passing order. Subsection 4 of section 75.
You did not apply for that.
But it is not required, my lord. Your lordship may kindly see subsection 4 of section 75.
No, there
70?
needs to be a request.
Subsection 4 of section 75.
75, why will you go to 75?
It says, my lord, if any adverse order is passed, my lord, in that case, before passing that order, my lord, an opportunity of being heard should be given against whom order is going to be passed. 75(4). On that score, I place, my lord, decision of Honorable Chhattisgarh High Court also.
I got the offense central.
And 71 says, 73(1) says, my lord. Lord, I have book.
Not book, we have book. ये ट्रैफिक से लेके लगे सब कुछ देखो নহয় পালো তো পলে লগতাৰ এখন মই ভৰাই ৰাখিছো অসমত তাৰপিছত এইখন চাওকচোন
And rule 26 says, my lord, authentication of the order or notice.
70.
But your lordship may kindly come to 73, my lord. It says about
General
notice.
provisions for where the service of notice or hearing is stayed by any court of appeal at the periods of such stay shall be excluded in computing the period specified in the month as the case may be. The appeal at this provision is there.
Yeah,
Is not sustainable for the reason that the charges of fraudulence where an order is required to be issued in pursuance to a direction of the appellate authority. Opportunity shall be granted where the request is received in person from the person. I did no such insurance. Now tell me whether you will be getting the benefit in view of section 16(2).
16, yes, your lordship.
Now, in view of the judgment of the division bench.
In case of fraud, here there is no case of fraud.
No. 16(2) is not a fraud. Division bench judgment is what?
My lord, if department can proceed in case of fraud and my lord, That is the division decision, your lordship, in case of India Plus.
So against fraud, the department can proceed.
My-
There's no quarrel with that. But otherwise, you are going to get the benefit.
My lord.
Here is a case of an input tax credit.
My lord, but what they are saying, allegation, excess utilization of IT, excess utilization of input tax credit.
Where?
The order passed against us on the ground that we have excess utilized ITC. Your lordship.
Page 28 it is mentioned.
Page
Okay.
28, it is mentioned, your lordship, grounds.
20,
28.
28. Ground summary of the so-called excess utilization of the ITC grounds. X interest penalty. No, excess utilization is taxes demand so and so, so and so. What is this PDF business? Aurora Fine Arts PDF SCN. Page 29. How is it possible that you don't have a show code?
Yeah. Specifically, they said that no, it was not there.
And what is this page 30? Is that a part of that?
Yes, it is part of it.
Part of that.
Part of the show cause?
No, part of this, my summary of proposal.
That is it. So this is the show cause.
This is not so good, madam. They have given no opportunity, but madam, after this, madam, we can't give our reply, your lordship.
Why?
They have already determined, my lord, tax liability, your lordship.
No.
In SOCOS, my lord,
You have filed return is so and so on examination of Iman, and Iman, it is found that you have not declared your correct so and so, the above is the excess so and so. So this is what he is attachment to the determination of tax.
my lord,
That is why it is a part of it.
part of.
And then you are asked to show cause.
My lord.
I think this is the document date by which the reply is to be submitted.
No, my lord.
When did you get this document? Isn't this a part of that show cause?
Summary of SOCOS. This is not for SOCOS.
How will you get this document?
They have sent along with this, it was
How?
in portal, your lordship.
So in the portal, this is the document, page 29, down below, Aurora Fine Arts PDF. Is this the document?
No, my lord, this is not the document. That is the SOCOS notice.
Then where do you get this document?
Along with, my lord, summary of SOCOS notice, this document, my lord, date must be there, your lordship, same date, in fact.
Date is what?
On the same day, my lord, it was uploaded in the website, your lordship. 28/9 to page 34, your lordship. Same day, at the top.
Huh?
28, page 34, date is given, your lordship, 28/9/2023. And summary of SOCOS notice is also when 28/9/2023.
So all these are part of that.
Summary of SOCOS.
Then what happens?
Then they
Then
have
he
passed
passes
order.
that order, excess IT. Does this have any correlation with this?
On the basis of that,
A show cause notice referred to in the section A Iman, since no payment has been made within 30 days of Iman. Available with the Iman, if any demand is, please note that the interest, if any, has been levied from
You may see page 41 for a minute.
it's a attachment.
Page 41.
Hmm.
Response of the taxpayer after the charge.
Taxpayer has agreed for the
This is false, my
following
lord.
amount
The
in the SCN.
My lord, in the petition, I have categorically denied this, my lord, because we have not received SOCOS notice, we have not agreed at all. We have
No,
not
no.
given any reply.
Wait, SG ST 36 819 is the schema. Observations and conclusion of the assessing authority agreed with the fixed term. Collection of the remand 00. Amount to be proposed in the notice. In this notice is 23 lakhs. 3 lakhs 8,000.
Para 18, we have denied you.
What is this? At page 45, 46, what are these?
There's that central notification, my lord.
Huh?
46 extension notification. Now this is
No,
not.
not 46, 45.
They have given calculation, your lord.
Now, if you, oh, how is this attachment to the determination of tax? Is this Mr. Bogoi, you do one thing, you make your person come and do some homework and show to me on the next day, how are these related with this page 30 annexure 2? Okay?
Well,
you have a look at this because this is how it is. Now, attachment to the determinant, how does this document come into? And if it is dated the date of the show cause notice, isn't this a part of that? Taking into account that you are doing all these things in this manner. So this has a relevance out there. And this, what is the correlation of annexure 2 with annexure 4? Okay. Annexure 5. Annexure 2 with annexure 5. Because DRC 07 is the final. So how do you correlate? Because this is the date, you see, so cause notice 28/9/2023. ARN number, reference ARN number.
So man, there will have to be a Sokos.
Huh?
Page 40. Sokos notice ARN number so and so 572. The lordship will turn to page 28. There, my lord, the summary of the Sokos is, my lord,
No. Therefore,
465
don't you
of
think that this attachment yes, finally see page 29. Okay. See the total amount 25,73,776. You get it?
yes.
Finally come to page 33. See the correlation here. Down below.
Yes. 25,73,776.
Then so you ask your person. How does this document come into being? Annexure 2. List the matter again on 17/8/2017, 9/2024 at 2 p.m. On which date Mr. P. Gugoi shall apprise this court the correlation between Annexure 1 and Annexure 2 read with Annexure 3 and Annexure 4. Your people has to be more careful.
Till then, your lordship kindly protect me.
What protect? You have come in the month of October. August, nothing has happened. What is going to happen in another 6 days? No heavens will fall.
Your lordship word is good enough, your lordship. Now it will not be happening. Deeply.
Yes. Mr. Mishra, what is this? Again, he has also again filed another affidavit.
Opportunity of hearing them.
They have filed an affidavit. They have said that they have not passed any order under section 73(9), my lord.
Huh?
They have not passed any order under section 73(9). Lordship may kindly see their affidavit, my lord.
Where page?
116, my lord. Paragraph 5 and 6 of the affidavit, my lord.
Found not satisfactory by the judicial that as the reply to the DRC was found not valid, the registrar issued notice in a month bearing a fixing date on month. The taxpayer submitted its reply in DRC 6 on demand and the same was found not valid. DRC 7 was issued on demand with a total demand of a fixing so and so. Now tell me what is this?
My lord, first they have to issue order under section 73(9). Thereafter they will upload this form DRC 07 in the portal, my lord. There is no order till today, my lord. Under section 73(9). I have annexed the proceedings, my lord, at page 109, my lord.
You say that they are in your favor? This affidavit is in your favor?
They themselves saying that they have only issued DRC 07, my lord. They have not. They themselves admitting, my lord. They are not whispering about issuance of order under section 73(9), my lord.
Similar manner, no adjudication is required under section 1 has been required.
In paragraph 6, my lord, they said yes, DRC 07 is a system generated notice, my lord. In paragraph 6, my lord.
I have asked them to obtain 2 instructions as to whether the order under section 73(9) had been passed and whether any opportunity hearing was sought for by the petitioner prior to the passing of the order, if any, and if so, whether an opportunity was granted. What is your reply, Mr. Boy?
Well, so far as this particular hearing opportunity that we have, my lord, stated that, my lord, inadvertently, though a request was made, it could not be made, given. That para 7.
How do you take care of this?
73(9).
Huh? Now, then in that regard, this order, and whether there is an order under 73(9). What is this DRC 1? Where do I get it?
Is summary of my lord.
Lord will find it in the. There is a summary of.
This issued under rule 142, my lord.
Rule
142, my lord.
Notice in order for demand of amount payable that the proper officers will serve the notice under section 3 so and so or demand or is under section so and so, comma, a summary thereof electronically. So the notice will be in summary.
That's why my lordship may kindly see my lord in the this particular form, my lord, in the index.
Page
In the act, my lord.
It says summary thereof, my lord. Summary of the notice, my lord.
thereof,
It is Roman 18, my lord.
electronic, a summary thereof electronically inform here. A statement under section 73 or remand or 70 of the summary thereof electronically inform DRC 2 specified in the details of the amount payable. DRC 1, where do I get it?
DRC one is paid 449.
449. DRC 6. Okay, DRC 1. DRC. Summary of the so-called defects, grounds, text due. This is the so-called. Only applicable column so and so, text remains so and so. Then intimation of tax ascertained as being payable under 73(5). So you see, in the earlier case, I think this will be under DRC 01A, ascertainment of tax. Remember that?
Yes.
Annexure 2. It seems something like this.
DRC one A.
Reply to the communication for payment before use or so-called notice.
My lord.
Then DRC 1 is being given. Then what is this DRC?
But my lord, there is no format of so-called notice, my lord, in this particular, my lord, in the act. Parent act.
No, from here it reveals that the notice under so and so, comma, a summary thereof,
Dot.
electronically informed DRC 1. So you don't require to give anything more. Comma, a summary thereof electronically informed GST 1. When do you have the comma and so and so, statement under so and so, a summary thereof, electronically in DRC specifying the details payment, the proper option before service of notice to the person chargeable with interest so and yeah, as the case may be, communicate the details of any tax payable as ascertained by the said officer. This is the ascertainment which was there in Annexure 2. Remember?
My lord.
In the earlier case.
One.
Now, where is the order? You passed the order. Order is to be intimated how? Here. Say 5, 142.5. A summary of the order issued under so and so shall be uploaded electronically in Form DRC 7, specifying therein the amount of tax, interest, and penalty as the case may be payable to the year. The order referred to in 5 shall be treated as notice for recovery, where rectification has been passed. So this will be done there. The
DRC
representation.
07 has been given, one.
Huh?
DRC 07 has been given.
My section 79 says, they have to be in order.
So,
In the summary
how do you
thereof.
take care of this? A
My lord.
summary of the order issued under so and so
My lord.
shall be uploaded electronically in demand specified therein so and so. Does it say anything by the rules? How the order would be passed?
But section says, my lord, section 73 says they have, otherwise, my lord, the word thereof would not have been there, my lord. There has to be an order and the summary thereof has to be uploaded, my lord.
Huh?
There has to be an order first, my lord. Thereafter summary thereof.
Where?
Summary of the order, my lord.
Where is it mentioned?
My lord, sub-rule 5, a summary of the order. A summary of the order issued under section 52 or section 62 or 63 or 64 or
Shall
section
be
7.
uploaded electronically in so and so. But where is the order? Yes, see, the representation referred to in subsection 9 of section 73 or subsection 9 of 74, or the reply to any notice issued under section which summary has been uploaded electronically here under shall be furnished in so and so. Where is the order requirement?
Lordship may see section 73 first, section 73 9.
The proper officer shall, after considering the representation, if any, made by so and so, determine the amount of tax, interest, and penalty equivalent to 10% of the tax, whichever is higher, due from the person, and issue an order.
Order.
Yes, the officer shall issue the order under remand within 3 years from the date of furnishing of the annual return for the financial year to which the tax not paid so and so availed to so and so. Anything under so and so shall be payable where any amount of self-assessed. Where does it say that it has to be different?
Now,
He
my
may
lord,
pass an order
now, my lord,
and
rule-
then he'll make a summary.
now, my lord will see rule 5. A
Ah.
summary of the order, my lord. It says summary of the order.
Ah.
Then there has to be an order and summary thereof will be uploaded of the order, my lord.
Where?
Sub rule 5, 142, sub rule 5, my lord. A
Where
summary
is the
of the order,
thereof?
my lord.
A summary of the order
Of the-
issued on so and so shall be uploaded electronically in a month, specifying therein the amount of tax so and so. The order referred shall be treated as the notice for so and so. Now see number 6. The
My lord.
order referred to in subsection 5 shall be treated as notice for recovery. So subsection 5, that is the notice for recovery. This will be issued to you.
But rule 5 say, my lord, order passed under section 74, 73 or section 52. There has to be an order, my lord. In other cases, they have issued order, my lord. I can place the instances, my lord, but they have been regularly issuing orders, my lord. Otherwise, your lordship will say DRC 07 does not contain anything, whether any reply was submitted or my lord.
Summary of the order, rule 100, 103. Now let us see what is rule 100. Provisional assessment. Yeah, assessment. The order of assessment made under subsection 1 of section 0 shall be informed GST so and so, and the summary thereof shall be uploaded electronically in DR7. Then they file an appeal.
Document 451, the form GST DRC 07, the format. 451.
Summary of the order.
Summary of the order, my lord, there is nowhere
Details
any
of the
column.
order number. So there is an order number. Where is, let us see. Is DRC 7.
Page 106.
106. Order number 1, order dated 4/1, financial year so and so. Issuing excess claim. What type of order is to be passed?
My lord, take give an order.
That you give reasons? No.
It contains reason also, my lord.
Why?
I have submitted my reply, my lord.
Or you give a show cause?
Summary was given, we have given a detailed reply, my lord. Now, lordship, our reply is of for 20 pages. And now the order is of 1 page. It says order number, date, and this amount. And my lord, my contention is that there has to be an order, my lord. Summary, it says summary of the order. That means there has to be order, then summary thereof will be uploaded, my lord.
So in the records, there has to be summary of an order.
The summary is that 07. Now order is not there. That's why I have annexed the proceedings, my lord, page 109. Lordship will see the proceeding at page 109 of my petition, my lord. At the right hand side, it said, my lord, reply furnished pending for order by tax officer.
This is 29/11. No.
My lord.
This is dated?
My lord, the screenshot was taken on, my lord, 10/5/24 at page 110, right below, my lord, right side below, my lord. This screenshot was taken on 10/5/24, my lord. On that day also, my lord, the status was showing, my lord, pending at the end of the office for issuance of order, my lord.
Lordship, may kindly see page 111, my lord. 111, my lord. Lordship will see orders highlighted in the left side, and it is, my lord, where the details to furnished, my lord, it says no record found.
What?
111, my lord.
There is no record found. So normally it is there.
It is there, my lord. Orders uploaded and summary is also uploaded, my lord. That's why, my lord, they in their affidavit, my lord, they are saying it as a notice electronically in their affidavit, my lord. They are treating it as a notice, my lord. DRC 07. They are not treating it as an order, my lord. In their affidavit, my lord.
The government will pass anything. I'm not on that, but
My lord.
you see, what do they say here? There are 6. So and so show cause 1A, which was found not satisfied, that as replied here was found satisfactory. Is now observed in one bearing number in one fixing so as that they is 6 on one and on the same day. And as the same was when DRC 7 was issued bearing reference number with the one
So and so for reply.
the date of I on or before you. What is their reply? Where is the scope of a reply under DRC 7?
That's why I'm saying, my lord.
Yes, Mr. Whatever affidavit is this? A reply to a DRC 7?
Then in paragraph 6, my lord, they say this DRC 07 is a system generated notice, my lord.
You do one thing, we state and there is no hearing. And you produce the record, you shall file an affidavit as to whether there is any order passed.
Every 3 times.
Any order passed or so that there is no order passed required. I heard Mr. R.S. Mishra, the Learned Counsel, appearing on behalf of the Commissioner. I have also heard Mr. B. Gogoi, the Learned Counsel, appearing on behalf of the respondents. From a perusal of this court had issued notice on 7/8/2024 and asked the petitioner and respondents to apprise this court on 2 aspects of the matter as to whether the order under section 73(9) of the AGST Act 2017 under the CGST Act 2017 have been passed and whether any opportunity of hearing was sought for by the petitioner prior to the passing of the said order, bracket if any, and if so, whether any opportunity of hearing was given to the petitioner. The respondents have filed their affidavit wherein there is no clear statement to that effect that there is an order passed. What has been mentioned in the said affidavit is that there is that after hearing after the taking into account the replies so submitted by the petitioner, the DRC, the summary of the order in DRC 07 was issued on 4/1/2024. Mr. R.H. Mishra, the Learned Counsel, appearing on behalf of the petitioner, referring to Rule 142, bracket 5 of the what rules?
CGST rules, my lord.
Central Goods and Service Tax Rules 2017. That the reference therein is that the DRC 7 shall be a summary of the order, and he therefore submitted that there has to be an order to be passed in pursuance to section 73(9). In addition to that, the Learned Counsel, appearing on behalf of the petitioner, also drew the attention of this court to the affidavit so filed by the petition respondents, wherein they have at paragraph number 7 categorically admitted that though the petitioner sought for an opportunity of personal hearing, the same was not granted inadvertently. The Learned Counsel, appearing on behalf of the petitioner, further drew the attention of this court to section 75(4) of the CGST Act 2017, which mandate that a personal hearing is required to be given. Full. Taking into account the above, this court prima facie is of the opinion that that certain interim directions are required to be passed in the instant case. Accordingly, this court directs the respondent authorities not to take any coercive measures upon the petitioner on the basis of the summary of the order dated 4/1/2024. The respondents are directed to submit a further affidavit giving specific details as to whether there is an order passed under section 73(9) of the Act, CGST Act 2017. This court, however, further observes that the respondents would be at liberty to take a stand that such orders are not contemplated under the Act of 2017.
Declare by mail.
Date, my lord.
Oh, when do you want it?
Same day, my lord, as the earlier case.
It's the matter on 17/9.
Declare by mail.
Yes.
In the morning, there was a partner's matter, Lordship. In the morning, I couldn't appear before your Lordship. There was a partner's
Tell me.
matter.
You
Here,
are
Lordship,
asking a writ against whom?
against respondent number 1, Lordship.
Writ against the Assistant Commissioner of Taxes is filing a writ petition against, why the respondent number 1? Against the Commissioner of Taxes?
Lordship, here,
Our writ is maintainable, tell me.
Lordship, the revisional authority on delegated power by the commissioner has passed the common revision order. And later on, it was found that the discrepancies that the assessing officer found while making the assessment, that was discarded by the revisional authority without any basis. And only, and since the amount involved is a huge amount of different assessment here, Lordship, that's why, since it was a delegated power of the commissioner, and that's why that order was.
Will issue notice, but you issue notice to the Commissioner of Taxes. Who is going to appear? Who will take the notice? Tell me.
Lordship,
Who is going to take the notice? You.
no. So they,
You
they
appear
have-
for the Commissioner of Taxes.
No, in this case, they have appointed someone else, Lordship.
Yes, where Mr. Bigoway. He's been appointed.
Yes.
Then, thank goodness, Assistant Commissioner of Taxes files a writ against the
Because
Commissioner
the
of
Joint
Taxes.
Commissioner on the delegated power, Lordship,
Huh?
as provided under section 3 of the VAT Act, Lordship, the appeal power was.
Yes, Mr. Bigoway, you are accepting notice.
KK Dutta will appear.
Huh?
KK Dutta will appear. Ma'am. I will, on my part, it will be difficult. KK Dutta will appear. Ma'am. He is otherwise a counsel. And he's a pro forma respondent. My lord.
Then how is a writ maintainable? Tell me, how is a writ maintainable?
It's difficult for me to make a submission at this stage.
How is a writ maintainable?
Lordship, here we have come before your Lordship because we have filed the.
Let us assume, let us assume tomorrow the advocate, Assam Board of Revenue passes an order. Then what happens? How is a writ maintained
Lordship,
by the state against these officers?
Lordship, here we came before your Lordship because the Assam Board of Revenue was not progressing due to lack of quorum. And the matter is pending since 2021, the statutory appeal, Lordship. In the meantime, the respondent, after filing of the statutory appeal, they have also approached this honorable court, claiming for the refund as directed by.
Pay the refund. Release the amount, more particularly the principal. The court has to be more concerned about the state's finances than the state. This is the state of affairs which is happening. You pay that amount, the principal. I'm not going to stay. I may only stay the interest, not the principal. You have to pay the principal. Because you see, otherwise again you take the money. What stops you from there? You are filing these for the refund. Very well.
No,
But how do you
this,
hold it? How do you hold it after the assessment order has been passed, a revisional order has been passed? Tell me.
Immediately, Lordship, we went before the Assam Board of Revenue as provided under that, but due to the lack of quorum, Lordship, that's the reason, Lordship.
Lack of quorum, no quorum, it's a different thing. But how
Otherwise,
do you take care of
by
that?
this time, Lordship, the matter would have been settled, Lordship.
You know, yes. Let us do one issue a notice only. Let us issue a notice, let's see what happens. Issue notice making it returnable on 4th of November 2024. The petitioner is directed to take steps upon the respondent number 1 and 2 by registered as well as we usual process within by tomorrow. Footstep. The petitioner herein have assailed the order dated 26/2/2020 passed by the Joint Commissioner of Taxes, Assam, whereby the assessment orders which were passed by the respondent authorities, assessment orders which have been passed by the assessing officer have been set aside. The respondent shall be at liberty to file their response, shall bring on record their stand by filing their response.
Lordship, this case was in respect of the VAT, and the next item is in respect of CST, Lordship, for the same assessment.
Well, same order.
Same order, the common order was there, but this is in respect of CST.
Okay, same order would do.
Yes.
First of the maintainability of the reputation, however, is kept open. The admission.
But for the last occasion, your lordship directed to submit inspection. Last order 16/8/24.
Yes, madam, any instruction? Instruction. This is this Komalpur matter.
Yes, ma'am.
He has filed an application for cancellation of the mutation granted in favor of the private respondent. The question is whether there is what the authority has done. That is what I asked you. List the matter again on 13/9/2000. 13/9/2024, on which state Ms. S. Sharma shall obtain the instruction as sought for by this court by the order dated 16/8/2024. Yes, any urgent matters to be here in terms, anything?
Lordships, may I mention serial 50, Lordships?
Oh, yes, what is that?
Lordship, that was the
Oh, yes.
affidavit I have filed my additional affidavit also, Lordships.
Okay.
If your Lordship says any other day, your Lordship may fix it, it will take 10 minutes hardly, Lordships.
Item number 50.
50, Lordships.
We'll take it up tomorrow at 2 o'clock. Finish it up.
Grateful.
Well, there's nothing out there because he has already stated
Lordship.
I only asked you to file that affidavit. That is the investigation matter. no?
Lordship, section six
You,
two B.
you have no problem with that Isha Industries thing, na?
Yes, no problem with that.
So the others have been duly approved by the government. He only wanted to take instruction. Mr. B. Gogoi wanted to take instruction in regard that Riddhi industry.
State authorities have issued that particular letter. We have not-
16.8.
Yeah.
16.8, na?
Lordship, 16.
Okay. We'll have it tomorrow at 2.
Grateful.
Item number 50 tomorrow at 2.
Grateful. dear.
My lord, item number 52, my lord.
Yes.
So madam has come from Allahabad, your lordship. We can fix a date, your lordship. Last occasion, your lordship wants to dispose the case. That refreshment.
Which one? The first one or the second one?
52.
Madam, the first one or the second one? The first was the writ petition you moved unlisted.
Right.
That's the matter. Both are together today, I said.
No,
Because
this
you
is
came
different.
today
This is
because
different.
there are another matter.
Another matter 51, your lordship.
51.
This matter has become infractual, your lordship. That agreement part, that,
It has become infructuous.
yes.
Which matter?
This particular item number 52.
Infructuous?
Yes.
No, she won't.
No, your lordship, I have given the reply with regard to some judgment of the Supreme Court, your lordship may hear. Kindly fix some date because stay has not been extended. After 1 month, your lordship can fix some date.
Okay, 51 and 52.
Yes.
Mal-
Both your matters are 51 and
51 is on admission. Your lordship, some order has been come from the Honorable Supreme
okay,
Court.
51 and 52.
Mal-
What Supreme Court order has come?
In 51 also.
What has come?
They have stayed, your lordship.
Well,
Mal-
so you got to stay there.
My lord,
In 51, you have got to stay.
say, lordship. The
Okay.
matter has been fixed for the railway that returnable at 9 September, your lordship.
Okay. Item number 51 and 52. When do you want it?
After 1 month, your lordship.
Okay. Item 51 and 52 list with matters on 13th of November
Deep, deep,
2024.
deep, deep.
Item number 49, there's an interim order till today, man.
49.
49.
Okay, list this matter. What is that matter about?
Regarding the challenge of GST order, my lord, it was passed beyond the time frame, my lord. It was passed on 4th of May, my lord. Last date was 30th of April, my lord.
What matter is this?
Regarding the GST matter, my lord, they have issued an order, my lord, demand order, my lord.
56? No.
Beyond 56, they have issued the order, my lord.
Beyond 56 also.
My lord, yes, my lord.
Okay. So list this matter again on 17line. Let's see. Interim order partially shall continue.
Item number 56, there is an interim order, Lordship. That
Item number
56, my lord.
56.
Interim
List
to
the,
continue, my lord.
list the matter again on. When do you want it?
22. Except 20, my lord.
Okay, list the matter on 6th of November.
First.
Interim order partially shall continue to.